Here, we will start on time.
We're ready, Chris.
We're ready.
Good. I'm Chris Howard. I have inherited the chairmanship of this august annual event. Thank you all for attending for the 3 hours of ethics credits we're going to cover today. I thought we'd start off by hearing from an opposing counsel we all respect, the august former president of the Washington State Bar Association, Mark Johnson. And if you aren't already sympathetic with that introduction, he also advises lawyers on ethics issues. He doesn't just sue them, he advises them. So Mark has been one of my favorite counsel to have on the other side for the last almost 40 years. And I know that he's a frequent lecturer on these topics. So with no more than that, Mark, I'll let you take over.
Thank you, Chris. Good afternoon, counselors. I sort of have the, we're sort of starting with the cleanup part of the presentation. That is, I've kind of got the potpourri. I'm going to talk about recent ethics opinions, some recent decisional authority ethics opinions, being both the ABA and our WSBA ethics opinions. I'm going to touch a little bit on cybersecurity, you know, how, because we now have rules that our RPCs mandate that we know a little bit something about technology. But what I want to start out with is I want to start out and spend some time discussing where the claims, the malpractice, the civil liability claims against lawyers come from, and also where the grievances are most likely to come from. I'm going to use two documents in this PowerPoint. I'm going to use an ABA study, their most recent study of professional liability claims. The ABA has done about 5 of these, I think, going back probably 20 years or so. And basically what they do is every 5 years or so, they collect all the insured legal malpractice claims. They collect data regarding those claims from insurance companies, and they put it together in a book. And it's kind of, it's one of the most useful ABA publications that I know of. It's called Profile of Legal Malpractice Claims. The most recent one is 2012 to 2015. I'm going to use this in the PowerPoint. Then I'm going to use the WSBA's Office of Disciplinary Counsel 2016 report on where the grievances are coming from. You know, they charge you for this. The ABA is the most entrepreneurial organization, of which I'm more. Hello there. And for example, when I'm going to be talking about ABA ethics opinions this afternoon, I can't actually show you the opinion up on the screen because you have to get permission from the ABA for ethics opinions. I'm not talking about their, you know, their texts and their books that they publish. They claim a proprietary right in their formal ethics opinions, which are supposed to guide us, and many of them end up being incorporated in our rules of professional conduct. But they will either charge you or they'll, you know, it's kind of ridiculous.
They've charged every time I've asked.
Yeah. You know, and sometimes you can poke around the internet and you can find a copy of a recent opinion that's made its way out of the dark tunnel of the ABA, but generally speaking, we've got to pay for them. So I'm just going to be talking about those more than showing you the text. So let's see if the clicker works. Oh wait, it doesn't. That's right, I got to use this. Okay. So what what I'm going to talk about is more or less the interplay of the ethical grievances against lawyers and civil liability claims. And at the end of the presentation, I've got some slides. You know, the ABA's booklet on legal malpractice claims, the 2000, what did I say, 12 to 15, the last version of this. And you guys are going to be very pleased. Your niche in the practice, as opposed to mine, we are always plaintiffs' lawyers, except for one publication. That was during the nadir of the economy when the real estate market collapsed around the country. Real estate was the #1 area of claims against lawyers. Every other publication, like I said, they've done 5 or 6 of this. It's always been plaintiffs' lawyers, far and above #1. Defense lawyers are down around 2% of all claims. So you're pretty much virtually immune, but I think you also know the practical side of things. That if the insurance companies don't think you're doing the job, they'll just take the work to somebody else, which is kind of the equivalent, perhaps, of a lawsuit. Of course, we're also going to talk about a couple Supreme Court decisions here, Washington State Supreme Court, last couple of years, which have been, I think, very beneficial to the defense bar, the civil defense bar, when it comes to, not being on the, as I refer to, the southern end of the caption. So, where do the malpractice claims and ethical grievances come from? We've got these two documents. We've got the ABA study on your left, on our the profile legal malpractice claims, and then our 2016 WSBA discipline report. They do it every year. It's a good document. It's interesting. You can get it online and look at it. So the ABA, basically, they published this in September last year, analyzed 44,000 claims against lawyers by area of law, number of attorneys in the firm, type of activity, and type of alleged error. The way they sort of massage the data, it isn't perfect, but you certainly can draw some important conclusions from them. One that you probably already are aware of, especially those of you that defend lawyers and legal malpractice claims, and that is deadlines are deadly. I mean, it's 25% of all claims against all lawyers, approximately, I think, are results of missed filing deadlines, statute of limitations, tort claims, all these things. And the second document, the WSBA discipline report. The Office of Disciplinary Counsel got about a little over 1,800 grievances last year, which is actually one of the lowest totals in a long time. I think folks might be happier with us than we thought. This shows that we've got about 32,000 lawyers in the state now in 2016, about 1,800 grievances. You see that it's gone down. I'm not sure why that is. Because it doesn't take much to file one. You just go online, fill out the form, and send it in. And this is, again, these are just grievances filed, not circumstances where the bar has opened an investigation into a lawyer's conduct.
Mark, if you go back further, does it correlate to economic times?
I'm not sure what happened in 2008. Clearly, the civil liability end of things did correlate to the economic times. It was shocking to see that real estate lawyers #1. This is, it's a title plaintiffs' lawyers have had every other year. One we'd love to give away, but I don't know whether it's the quality of the representation or, again, it's that deadline thing. But plaintiffs' lawyers get sued more than anybody. In fact, the Bar Association's new carrier, for years the bar's carrier was CNA. In other words, you could buy it through CNA. They make a donation to the WSBA. Something that we did when I was on the Board of Governors. They moved to, is it Alps? Yeah, Alps. They have a carrier in Montana. And Alps won't write my firm. I thought, well, I'm a WSBA guy. I was past president. I'm going to look out for the WSBA's interest in this. And I sent my stuff in. I said 100% plaintiff's practice, which basically it is, except for a little ethics consultation, that kind of thing. I do expert witness stuff, but they wouldn't write us. They said you're too high risk, so there you go. If you look at this pie chart, there's not a small hunk of sort of the nature of the grievances. You can expect sort of where it comes from: unsatisfactory performance, personal behavior. Those are, that's kind of impaired lawyer thing. Lawyers that are having, and I say, if you get a DUI, the bar probably won't discipline you. If you get 3, they're going to want to sit down and have a talk and maybe have you take a vacation. And I'm not saying that about the DUIs because you guys are serving beer here. The opposing clients, this is who filed the grievances, 22%. Those generally go nowhere. You can imagine. But former clients, a current client, probably about 40-some%, almost half of all the grievances that. Now, here is grievances by the area of practice, and this again is the WSBA report, not the ABA's report. Criminal, family law, and torts are the top three. Criminal law is, you know, I'm sitting in jail, I was innocent, and I'm here because my lawyer screwed up my case. A lot of those go away. It's interesting because on the civil liability side, I don't know if you got a copy of the little brief that I did. I sent it to Maggie.
I think she posted it for people to be able to access it.
Basically, it's about, I don't know, it's 15, 20 pages, but it's a summary of legal malpractice law in Washington State, and if you're ever really bored, when you get to the section about criminal law, you'll see that basically criminal defense lawyers in our state just about have a pass. You know, in order for, with a couple small exceptions, someone charged with a crime who wants to sue his or her lawyer has to show factual innocence by a preponderance of the evidence. And this was a case that was a 5-4, I think, decision. I'm not blanking on the name right now, but it, you know, basically it effectively.
Eng versus Martin.
Eng versus Martin, very good. Effectively took the cases out. There's been a few tweaks since then, but so criminal law, basically in our state at least, a high percentage of grievances, not a realistic risk, civil liability risk. You guys aren't even mentioned here, so you're doing pretty good. You know, torts, again, a lot of it has to do with you know, filing deadlines. We'll see it a little later. This is a list of the rules violation. You see down at the bottom, you know, safeguarding property. That's, you know, obviously the fees, the trust account overdrafts, and all that stuff are big areas of grievance. And you know, the bar does not do random trust account audits anymore. So, you know, because of the budget stuff. So the only way that a trust account violation will come to the front is if the bank kicks out, you know, a notice to the bar because the account is overdrawn, or the client keeps asking his lawyer for the money, and the lawyer doesn't pony the money up. There's a couple discipline cases where lawyers have actually blown the statute of limitations, been afraid to tell the client about it, and then called the client up and said, you know, hey, great news, your case settled, but the insurance company wants to make payments. And these lawyers have, you know, paid out of their own pocket the clients because they don't have insurance, for over a certain period of time. And finally, in both cases, the lawyers ran out of the money to pay the client, and ended up getting reported to the bar and disbarred. They made it a lot worse by just not saying, look at, you know, I mean, you know, from my perspective, knock on wood, we have not yet missed a deadline. I feel like I shouldn't even say that out loud, but the truth is, what you do, and your practices, this probably isn't as much of an issue, you just bring the client in the office and say you got a new defendant. That's all you can do. Here's Maggie with the coffee. So this just shows what happened in 2016. They disbarred 14 lawyers. You know, and not a lot of discipline. It's hard for me to see the screen here, but you know, total instances of discipline about 70 last year. It's been about consistent throughout. Since ticked up a little bit in 12 and 13, but
we can't read from here. Does that really say what the disbarments are for?
No, but they're part of the. You know, a lot of them are it's the trust account stuff for sure. But there is another portion of the WSBA discipline study that does tell you exactly what the disbarments.
Mark, are the disbarments just with respect to attorneys who are in Washington, practice in Washington? That doesn't include the reciprocal disbarments.
Yeah, I'm sure that if there were any, it includes that too.
Oh, okay.
Yeah, a lot of times it's you know, it's money. A lot of times it is diligence. I mean, you know, we forget, you know, the first RPC is competence, but diligence and communication follow right behind. And there's a comment to the diligence RPC. It basically says, and this is our Supreme Court is saying this to us, says there's no you know, basically negative act or omission by a lawyer that causes a client more angst, and makes them more angry than procrastination, lack of diligence, you know, not returning calls. Those things just, you know, I mean, we've all had the cases, you know, you make a mistake, take a case from my position, and no, maybe I should have taken it, and not getting along with the client, so it goes to the bottom of the stack. It's the worst thing you can do. It's like broccoli, you either eat it or get the hell off, get it off your plate. But so this is now the ABA report, and these are the claims in this last this 40-some thousand claims. Almost 20% plaintiff's personal injury. Then real estate is next. Family law gets a ton of claims, and you know, a lot of this is in the same on the grievance side. It's anger. There is the personal injury defense, 2.01%. Congratulations. You're almost footloose and fancy free there.
Well, there is a point worth making in that regard, though, which is one thing our insurance company points out is dabblers outside of their area get hit. So if any of the people in the room decide, oh, I'm going to give estate advice or this for my family or that for my family, you should never assume your family won't come after you. So dabbling in the other area runs the higher risk.
Dabbling is dangerous, for sure.
By itself, and doesn't protect you just through your insurance defense.
I mean, this is not an inexperienced audience out there, you know, but it's, if you get a case you've never done one before, or at least, you know, what I tell young lawyers is associate something. You know, half of a fee is better than no fee in a lawsuit. So these are the major types of activities. Notice the preparation, filing, transmittal of documents, again, the deadline stuff, commencement of the action or proceeding are enormously, I mean, it takes out almost half the claim, especially when you see this other little slide here. We'll get to it later, but they also categorized the errors, you know, kind of by the nature of the error. And what's interesting about this is if you take the intentional component of it out, the substantive is, you know, legal knowledge and so forth and knowing what you're doing, but hello, Mike. But you know, 46, 47%, and I think perhaps more, of all claims against all lawyers have nothing to do with legal knowledge. It's the bedside manner, the client relations stuff. It's the Ralph Cromwell refers to it as the drudgery. You know, the getting things filed on time. You know, having a calendar and a case list and looking at it. So you know, 46%, you can argue almost half the claims against all lawyers have nothing to do with legal knowledge. Under the administrative errors, you see, this is the sloppy desk sort of category. You know, when I give this little program, sometimes I use this clip from a movie that Walter Matthau was in many years ago, and where he was a plaintiff's personal injury attorney, not doing very well. He got a big case, and it's a great comedy. But his office is piled high with papers and stuff, and the insurance defense lawyers in a certain clip, they come in to visit him, you know, and he says, gentlemen, come on in. He's moving pizza boxes so they can sit down, and I can tell you how old the movie is. He asks one of the defense lawyers if he wants some Metrical, which probably, I don't you don't know what Metrical is? Yeah.
1960s.
Metrical for lunch bunch. So, but if you look at these errors, this is just classic, you know, the administrative, the meat and potatoes, as Ralph Cromwell calls it, the drudgery, and adds up to almost a quarter of all the claims against all lawyers. The reason I think that it's higher than that is this is how the ADA characterizes substantive errors. And I highlighted in red down here, and this is taken right from the report. The lawyer does not know about the deadline, a deadline thing, or makes an error determining what deadline applies or calculating when it occurs. To me, that sounds a lot like an administrative error, but what it is it's a deadline error. And so again, that gets you up well over 25% all claims against all lawyers just not getting stuff done on time.
Mark, for the people of the age in this room, the young people in this room too, I've seen this happen in Washington with people who haven't reread the rules in the last few years, and the rules have changed. So they think they know the answer.
Yeah,
The rules keep changing.
Well, and also, again, and a lawyer does not know about the deadline. You know, we've seen in a lot of these, you know, I mean, we all know the basic, everybody here, the basic statute of limitations for torts and so forth. And, but there are these other little types of work that lawyers do where they have very, very short, you know, statutes of limitations. And, you know, I see time and time again, a lawyer takes a case in Oregon, lawyer takes a case in California, a PI case, an automobile accident case. I've had 5 of these over the years, and for some reason, they just assume that every state in this country has a 3-year statute of limitations. And they blow the California statute or they blow the Oregon statute, and then there are lawyers working in Washington. So now it is a 3-year statute of limitations. I have 3 years to sue them because they're up here, you know, and it's, yeah, that again is the dabbling thing. You know, the conflict of interest, 4.5% or 4.15% of claims, that surprises me a lot because in my personal practice, incidences of conflicts have been a lot higher than that. I don't know, Chris, you defend the brothers and sisters of the bar. Where would you put that percentage in your practice?
I think that it's the growth area for allegations and deposition cross-examination. But I think that, you know, so there's a lot of grist for the mill. Most of the time, it's because the perception of what is a material limitation conflict has been growing from what people used to think. So most people think they didn't have a conflict even while they're being sued, being told they have a conflict. So it's the material limitation one that's growing. I don't know what the percentage is, but in every single malpractice case I have to defend, it's alleged. Whether it's really there is a bit grayer, but it's alleged in every single one.
The first legal mal case that I tried, it was in May of 1982 in Spokane. My opponent was, and I was, I think I qualify as definitely as a young lawyer then. My opponent was Bob Whaley, which is not a fair fight. Yeah, we did settle the case after opening statements, and there was an enormous conflict in that case. And what the claims rep said to me when we were exchanging, you know, the documents, the end, St. Paul was the carrier. I remember this because she said we get a file with a conflict and we mark it paid. That's what she told me. Now, I mean, I'm sure that, you know, you're going to look at whether the conflict really has legs or not, like Chris is talking about. But, you know, the thing is, it goes to the fundamental relationship of an attorney and client, because clients want champions. You know, I mean, you don't, you know, there's, you know, my clients are generally unsophisticated people who have had something bad happen to them. And you know, I've learned over the years they just don't want me to say a good thing about my opponent or the defendant. They think that I'm not going to be as you know, assertive in their claim. If I like, you know, John Graffey or I like Chris Howard, you know, they just think that I'm going to. Notice I didn't mention you back there.
I'm not hurt.
As long as you have, the thing about where the real growth in conflicts that people don't see coming is if your firm makes a mistake or arguably makes a mistake, and the client says, well, stay on to fix it, and you don't go through a full conflict waiver process to stay on to fix it, you're at risk for being told you have a breach of fiduciary duty and conflict by not getting the conflict waiver. That's the real growth area now for conflicts being alleged all the time. Similarly, for years, the same firm would draft the contract and handle the litigation on the conflict. And if you don't do at least a disclosure before doing that, that's a real growth for material limitation conflicts.
Well, you know, I was talking to John before the program here, and you know, he mentioned that he had just finished up a multi-party representation, you know, conflict sort of waiver, or and you know, we actually now. You know, our fee agreement has grown from about a page and a half, 30-some years ago to about 7-8 pages, because we put in stuff about social media. You know, we put in stuff about make sure if you communicate with us that you only use a cell phone or a laptop or whatever that is owned by you, there are some scary privilege waiver cases out there right now. I mean, scary, where in a criminal case, a lawyer is communicating with his client in a bank fraud case, and the client is using the bank's computer. And the court held later on that there was no privilege as to those communications. Or another case, a civil case, an employment case, where the employee suing the employer was using the employer-provided computer to communicate with the lawyer, no privilege. All those things coughed up, you know, so.
Those cases aren't all that new, so everyone
No.
should be warning their clients about
No, we have a, go ahead, I'm sorry.
And employer-provided cell phones can be an issue too.
Same thing, no, yeah, any, and so our fee agreement we have, and there's a WSBA opinion on it, you know, it's a spot-on opinion where they says, you know, yeah, there's a great risk if you're communicating in an unprotected device of having a privilege waiver, of a court finding a privilege waiver. So it's also, you know, you've got, it would seriously mess the case up, but it also is an ethical grievance. And we now, of course, we'll talk about these RPCs a little bit later, we now have, you know, we're obligated to keep up with advances in technology. And it's not enough to say, I'm a senior lawyer, I don't need to know that stuff, I don't need to know the difference between a cloud storage and a blockchain, you know, and which is kind of the new up-and-coming way to protect our technology. But you think, you know, well, I've got an ABA opinion, we'll discuss that later. So this is client relations, 13% of the claims, and again, remember the first, administrative, non-client relations, you know, withdrawal, fail to follow instructions, informed consent. So you take these two, you take the client relations part of it, and you take the administrative errors, and you get, you know, well over 40% of all the claims. That is not the end of the show. Well, that's interesting. I guess it is now.
That's actually the end of what I received.
Is it?
Yeah.
All right. So,
You'll speak louder.
here we go. So I can't take this, I gotta leave the
Do you
computer.
have a thumb drive?
Can I close it?
Sure. Do
Yeah,
you have a thumb drive?
you don't want to, you're distracted by that.
Well, I just want to put my stuff up here, it's more convenient. I'll just,
Yeah, don't worry.
all right. Okay, now I'm going to jump around a little bit. Cybersecurity. There's, when you think about what's happened with the iCloud hacks, not once but twice, where people, celebrities, you know, they have a penchant for taking pictures of themselves wearing less than I wear in the shower, and they, you know, and they end up in the public domain, and that's happened twice now. The National Security Agency's been hacked. So, you know, even the ABA recognizes that it's not a question of if, it's a question of when. But we have ethical obligations to keep our information confidential, and the reason why lawyers are enormous targets for these cyber criminals. There's a couple things that facilitate our exposure. We get things, and I'm sure you guys do every week. You know, every week we get suspicious emails, and you know what happens is you open it up, and all of a sudden all your data is encrypted, and you get some guy sending an email saying, okay, this is what it's going to cost you to release your data. But the reason lawyers are a target is because we hold a lot of confidential information. And the second thing is the cyber currency, Bitcoin, has facilitated the perfect vehicle for these guys to get paid. And they are, in fact, in it for the money. And there are stories, you know, a law firm out east, a small firm, a plaintiff's firm, you know, got all their data encrypted. They refused to pay the ransom, and the cyber terrorists released a bunch of their clients' medical records to the web. So it's, you know, there are conflicts. So cybersecurity, in conjunction with, you know, the recent changes to the RPCs and our obligation of confidentiality, which I'll discuss a little later, extremely important to know something about it. And the two areas where lawyers are most at risk are right in our very offices. You know, by not instructing, you know, our assistants and the other lawyers in the firm that if you get something from DocuSign and you don't have a transaction going where you're supposed to sign a document, don't open the damn thing. Don't open it. Look at the email address carefully, and what you'll see that it's not kosher. You know, it'll be, the DocuSign address will be a little bit off of what DocuSign's, you know, really is. And they're getting more and more sophisticated. They're camping on our servers, and they see that they literally can see and they have how we write. I mean, and this isn't some guy sitting in his mother's basement, you know, at a computer. These are banks and banks and banks and banks and banks and banks of servers in Eastern Europe and other places around the world that just, you know, just keep looking for addresses and looking for to penetrate security. And so you just got to be really careful what you open. So that starts right. The number one sort of deficiency is right at home, where some employee, you know, opens something up without thinking, and you're off to the races. The second area where that put lawyers at risk, and this is something that our Bar Association has addressed. We actually have a cloud storage opinion. The ABA does too. And but the second area are our vendors, and you know, we have, you know, it's sort of the back door to the law firm's data. There's a gentleman by the name of Dan Gary who's written a book called The 10 Commandments of, or he's written a book called Cybersecurity. So, and it's published by the ABA, one of the best books on this that I've read. And you know, when it comes to vendors, he says, you know, limit access in accordance with the need, conduct due diligence investigations into the background of vendors with access. Enterprise security is only as strong as its weakest link. Review existing contract language, understand vendors' cybersecurity protocols. Contractually bind vendors to security standards and protocols. And he has a few others, but you know, and the Bar Association has now told us that we can't just find some company to store data. We have to actually do a due diligence inquiry to satisfy ourselves that the data is going to be, you know, sufficiently protected, our confidential data. And, you know, I mean, most of us in a busy day-to-day law practice, that's kind of the last thing we're thinking of. But it is now, it's good practice, it's good for the clients, but it also is, it's pretty much standard of care, and you can expose yourself to an ethical grievance if you miss it. Now I'd like to talk about some recent developments. That was part of my assignment here, recent developments. So back, I don't know, it's been more than 10 years ago, the ABA started this in large part because of the advances in technology, just decided to look at our RPCs and to see if they were comporting with the technological reality of our day-to-day practice. It was called Ethics 2020, and that is when they adopted this comment to RPC 1.1, which is you know, the competency, comment 8, and it was amended to include an obligation on the part of lawyers to keep abreast of relevant technology as part of the duty of competence. And we adopted this in 2016. We adopted that comment, and we also at the same time adopted a change in RPC 1.6, our confidentiality RPC, to add a new subsection that includes a duty to make reasonable efforts to prevent inadvertent or unauthorized disclosure of confidential client information. And this is, because of the social media stuff, we think, well, the email is just like, it's like breathing anymore, and so we can get a little bit careless with it in emails we receive and emails that we send. Maybe 10 years ago or so, I sent an email to, it was, DOUG, somebody named Doug, and it went, by mistake, to the Chief Disciplinary Counsel of the Bar Association, Doug Enday, a friend of mine. So I became the first lawyer in the history of the practice of law to violate the rule of confidentiality and also self-report myself. I figured I'm going to take care of it in one click. It wasn't anything that was confidential in the email, thank goodness, and we all missend them. I think, if there's something that's, I think the simplest risk management tip on this, and really, these sort of seminars, they're about ethics and all this stuff, but really they're about risk management. That's kind of the foundation. But the simplest thing is if it's a very important email and you're sending it to somebody, and you've got 20 Marks and 20 Johns and whatever, write the email, finish it completely, then enter the address, because it makes you connect with the name, and you send it to Mark Johnson, Mark whoever. And it just is one of those, we send so many of these things every day, but it is a simple tip when there's again, if you've got something that's highly confidential and you want to make sure, just don't, the address is the last thing you put. So, another change, RPC 1.7, the ABA amended that in this Ethics 2020 thing to include a comment on advanced conflict waivers, and and there's an ethics opinion on it. I think it's I've read it more times than I probably should admit to, and I think it's just gobbledygook. But the WSBA Committee on Professional Ethics this year proposed adopting Comment 22. We have not had it yet. This is RPC 1.7, Comment 22. And it's lengthy, but basically it allows a lawyer to enter into sort of a prophylactic waiver, a preventative advance waiver of a conflict. And it's a lengthy comment. You ought to at least read it and be familiar with it. I think it's a dangerous thing. I think it's something that can work a lot better certainly with sophisticated clients, like insurers or something. But it's something you should know about. The Supreme Court, our Supreme Court hasn't adopted it yet, but they probably will. So that's new comment 22 to RPC 1.7. Yes, Chris?
To make that relevant to the people in this room, because that advanced waivers are not the least bit irrelevant. They're highly relevant to all of you. How many of you have clients or carriers who regularly accept tenders of defense? Yeah. And you have a tender of defense where you know you have an ongoing client who's going to want you to continue to represent them. So the capability of doing an advanced waiver in our practice area is highly relevant. So it's not an irrelevant thing. We are going to be some of the people using it most often. But you also have to remember one other thing, and that's elsewhere in the rules. Consent can always be withdrawn.
Yeah, the comment says that expressly. Yes, sir.
Yeah. So how long?
how can I phrase this? How long does a conflict exist? What I mean, you know, it's the prior conflict issue.
I'll cover
right?
that in my seminar. If you
Yeah, okay. So it's that prior conflict issue. You know, is there any period of time after which, you know, there's an assumption or a presumption that there is no longer a conflict? 5 years, 10 years, whatever?
Well, you know, Chris is going to handle it, but if it's not a substantially related matter, for example, if you're talking about something, you know, a former client conflict,
right.
somebody in the past. If it's not a substantially related matter, then you're probably in good shape. But the burden is always going to be on the lawyer to show that, you know, there isn't information or data that they gained in the prior representation that they're using, they could use to the disadvantage of the client.
Yeah, I mean, it comes up all the time in our insurance defense world where, you know, you've been asked to represent one client in a case, and then you do your conflict search and you find out there's an adverse party in the case they represented 5 years ago. You know,
right.
Somebody else in your firm represented 5 years ago, and those are always the ones I kind of wonder about.
Well, in one of the cases that I'm going to talk about in a few minutes here was the case that just came down, I think in September this year, against Forsberg and Umlauf.
Right.
And I want to tell you, I want to go into that in a second, but I want to talk to you guys about this case that you should read this case. It's an unpublished opinion by Jim Donahue, Chief U.S. Magistrate over here, and it's so only the Westlaw site is available, but it's 2016 WL 1615430. Atlantic Specialty Insurance Company plaintiff versus Primera Blue Cross. And there was a local law firm, a big law firm, was disqualified because of a... Were you involved in this case, Chris?
Colin wrote the brief, I argued the motion.
The motion to disqualify?
Yes.
Okay. Tell us about it. This is an important case for you guys to know. Hi, Colin.
This is a case where an insurance company, which is a fairly small insurance company in terms of staffing, that is to say, a very small office that handled claims for all of their subsidiaries, so their related entities, had an ongoing relationship with attorneys in one office of a multi-city office law firm. While an attorney in another office was working for their insured in a matter with disputed coverage, and I may get the exact who sued whom in what order, either appeared in or initiated the coverage action contrary to the carrier whom they were working for and whom they were also doing work for in another office. I think the really important part to know in terms of how it responded, when the carrier protested and said, "We think you're our attorney," the law firm's response was, "No, you set us up, this is your fault, not ours," and hot potatoed them and took a position that I think can fairly be characterized as this is the carrier, the client's fault, not the law firm's fault for failing to pick this up in their conflict check. That's a little oversimplified, but that point was actually addressed by the judge who pointed, or the magistrate who pointed out that that was a distasteful position to take in defense of the conflict. So it probably would not have been as draconian if they had simply responded constructively, but they were kicked off the case. They were left on the underlying case that they were defending, that they were kicked off the coverage case. Colin, did I get that accurately enough?
You know, I haven't read the decision since it came down, but I guess one thing that I would suggest is the opinion is interesting, the decision is interesting reading, and I think the best takeaway you can get from it is what some might characterize as a relatively low threshold of knowledge necessary to disqualify a firm from representing a client.
That's the key, you know, and so if you get into these, and this sort of is a little bit about, you know, the new rule with advanced waivers, because, you know, you can enter into an advanced waiver, but if you've got any data or information from prior representation and the case blows up, you know, the courts are going to kick you off like right away.
And let me also underscore one really important question that I get asked. I'm in-house counsel, as is Colin, but I'm also outside in-house counsel to a lot of law firms. And people always ask this question, do I have to run affiliates? How many of you ask that question when you're running conflicts? And this case happened because someone did not run affiliates.
Exactly why.
And while affiliates may not always conflict you off, under the fact pattern of this case, where the affiliates were all basically reporting to the same people in a small office of, I think, 3 people running all the affiliates, in this particular case, failure to run affiliates was fatal.
And I think Jim Donahue, he pointed out the small size of the carrier and a few things, but it's a long opinion. It's 14 pages. He's a smart guy, and he, for some reason, he really took to this case and felt like the issue should be analyzed. And I think there's some very helpful analysis in it, although it is a Western District unpublished opinion, especially for, you know, I mean, these insurance companies that own insurance companies that own insurance companies, and you're representing one of them. It's a case that you might want to read. Perhaps not perfectly germane to your bar. We're anticipating some changes in the in lawyer marketing rules coming up here, and it's kind of, you know, I mean, I started practicing in 1978, a year after Bates versus the State Bar of Arizona came out and said we could advertise, and that was like earth-shaking. You know, that we can't advertise, we're a profession, and all this stuff. And of course now you've seen, you know, the extent of the advertising on, you know, social media and videos on YouTube and all this stuff. But they're kind of the ABA, at least, and we'll see what our bar association does about it. They're kind of going to take the lid off of it. I mean, I think as long as if it's not misrepresentation, if it's true, I think you're going to be able to do it, and even to the point that you know, you can't do in-person solicitation, although not a small amount of that is going on in the bar these days, and it's troubling to some of us, but not on your side, on my side. But it's pretty much, they're pretty much going to take the lid off as long as it's not deceptive, it's not misrepresentation. We could very well see a much more open market. You know, part of it is, and I think in response to these non-lawyer sort of organizations that are proliferating like you know, LegalZoom and all these things, you know, where they're what the biggest change you might see, and this is I think would be a tectonic shift in our practice, is that they may very well allow lawyers to pay for referrals. You know, in other words, you know the rule, we can't take anything of value from somebody for referring a case to us. We can't share fees with a non-lawyer. The greatest impediment to a lot of these companies that are out there that are trying, these lead generation firms and all these things, the greatest impediment to their success, and I think this also includes AVO, which is now, you know, some of these lawyer referral companies they're starting to get into the business of rendering legal services. But the biggest impediment, that you couldn't share fees with a non-lawyer and you couldn't give somebody something of value for referring a case to them. Those are probably going to be out the window. You know, our Supreme Court still has to sign off on. I mean, the ABA can do what they're going to do. Our rules aren't perfectly aligned with the model rules, but they're pretty close. So what that would do is then, you know, I could sign up for some service and pay them, you know, whatever, X number of dollars for every case they refer to my office. That is a huge change in how lawyers do business. And again, I think it's part because you can't stop these companies. And you know, they're out there grabbing our profiles anyway and putting them on their websites. I actually gave a talk a couple of years ago and I was going through all these, you know, it was about all these companies like LegalZoom and, you know, all these other ones. But there was this, so I was kind of doing a search on the web, and I found this site called Rocket Lawyer. And so what I was trying to do on this Rocket Lawyer site is I was trying to discern if it was ethical for me to use their services. And what you have to, at least under the current state of the rules, what you have to show is you have to show that, you know, you're not paying for a specific referral. You're not sharing fees with a non-lawyer. And those are the two RPC prohibitions that are most germane to these sort of organizations. So I'm going through Rocket Lawyer, and I come to Seattle, and I kind of go, well, I want to see what Yahoos in town are on Rocket Lawyer, and of course one of the first Yahoos that comes up is me. They grabbed our law firm photos, and they grabbed our web address, and they put up there, and they've got this thing as, you know, this is available for you. And so, you know, they're just going to go ahead and do it anyway.
Did that come up because it knew who was searching?
No, I typed in Seattle, and I think I typed in Seattle and personal injury or something, and you know, and there were a few Seattle lawyers that had, in fact, you know, signed on, and they were fully integrated into this. And it's fine. I mean, whatever. I mean, if you're not sharing fees with a non-lawyer, you know, and you're not paying per referral, you can do it. But a lot of these things are really close to the edge. Those may all go away soon. I don't have a clock up here. I got 10. All right.
I was just about to give you that.
All right. You know, I think an opinion you should read is the WSBA opinion last year, 201701. No, I'm sorry, it came out this year. It basically it outlines what a lawyer can and cannot say when you're withdrawing. And this is a tough issue, and you can probably give a half-day seminar on the ethics of withdrawal. But you know, and of course it's going to depend a little bit on, are you withdrawing because your client hasn't paid your bill, or are you withdrawing because your client has lied to you? You know, and many other circumstances in between. But those are the two biggies. But you know, the WSBA opinion basically, it suggests, I think, probably good common sense procedural devices. You know, filing in camera. You know, the motion for withdrawal in camera, and the documents that may possibly, you could possibly be accused by the client of giving the opponents information they would not otherwise get, the breach of the confidentiality of Rule 1.6. But the most frequent ethics consultation that I give to law firms is on this issue, withdrawal. And and most specifically, what can I say when I'm getting out of the case? And it's a landmine for lawyers. But this opinion, I think it dovetails. I think it dovetails the standard of practice very well. I mean, I think what the standard practice should be is you don't go in there screaming, "My client's a liar, Your Honor," and you don't put pages of his deposition in the record that the defense can see. There may be obligations to disclose to the other side regardless if your client's committed perjured testimony, which again is the other half of that one-day seminar that you could certainly give on ethics. But and just last year, 2016, the ABA issued a formal opinion. This is opinion 476, which you probably can't get unless you're an ABA member, you pay for it. But it addressed withdrawal specifically in the context of the non-payment of fees. So those two opinions, our advisory opinion this year, 201701, on what you can say when you withdraw without violating the obligation of confidentiality, and then the ABA opinion, 476 on withdrawing when it's simply an issue of non-payment of fees, but you're going to run into some of the same issues, which is there's certain things you can't say, you know, and you got to keep that in mind. I always, you know, even though I do a lot of this, when I have an ethics issue come up, and we had one just about a week or two ago, and I hire Mark Fucili, who's my co-chair for the WSBA seminar we do every year in December. But you know, because I've said it once, I've said it 1,000 times, don't try to solve these problems yourself. You know, and get outside counsel. And let me give you an important reason why. So say you're representing a client and things aren't working out right for whatever reason. Maybe you think you've made a mistake. Maybe the client's misled you. Okay, so you stop right there and you go, you know, we probably ought to get out of this case or get some advice on whether we have to notify opposing counsel of our client's perjurious testimony or whatever. There is a case called Versus Law versus Stoll-Reeves in our state. This is a case, and it's in my brief, this is a case you darn well better know. That's a Division I case, right? They didn't go to the Supreme Court. They did not review it, I think.
And it's not, it's a minority opinion nationwide.
Well, here's the thing, is the opinion is a mess. It's a, or I'll say it this way, take that off the video. The opinion is not an ornament to clarity.
But may I point out that this is exactly the type of material limitation conflict we were discussing earlier.
That's right. And here's what happens though. So you've got this problem with a client, but you still have an existing attorney-client relationship, so you still have fiduciary duties to the client, the fiduciary duty of undivided loyalty, good faith, fair dealing, complete candor, all that stuff. So you're emailing back and forth with your partner saying, oh man, I wish we hadn't done that. And he says, yeah, you know, it's a mistake, but maybe we can get out of it. Okay, what Versus Law says is when the client sues us, those email communications are probably discoverable. And so, you know, we always look at in legal mail cases, we look at, you know, when the error occurred, and you know, and if it's during the sort of the representation continued on beyond that, we always ask in discovery for, you know, what we euphemistically refer to as the Versus Law request for production. We want those emails. However, if you want to improve your chances, and you know, this is where you say to the court, don't worry, Your Honor, I'll connect it up later. I'm about to connect it up right now. If you get outside counsel, you probably have a better chance, I know, you probably have a better chance of going to that attorney, talking to that attorney, and getting advice on how to extract yourself and or your client from this problem. You know, and so the outside independent counsel is probably your best firewall against your client later coming on and discovering. It doesn't mean those intra-office emails will be discoverable. They probably will be, but at least the advice you get from this independent counsel may not be discoverable. We it's in the context of the fiduciary relationship, and the courts can always look at that. But it improves your chances. And another thing is we can't see these things objectively, generally speaking. The reason I went to Mark Fucili a couple weeks ago on this thing is I wanted to make sure I was doing the right thing. And so I paid him a few bucks, and he walked me through it, and we out, talked about it, and I'm fine. And you know, I tell you, it gives you really, you know, whatever peace of mind you can get in this business, which is few and far between, that we can ever really rest. But you know, that is, I think, really important. So get outside counsel. You know, outside counsel can help you protect. You know, and some of those communications may be protected by Versus Law. I know there's a lot of debate on this. Colin, you disagree with me on this?
I was going to ask you a question, actually, which is, do you think that Versus Law would have come out differently had the law firm fully disclosed to the client during representation, we might have made an error, and here's what we might have done wrong? Because it seemed to me it turned less on, although it's about the model of clarity, less on whether you had inside counsel or outside counsel, and perhaps more on what did the client actually know.
Yeah, you never, that is spot on. You never want the client to say, you know, 6 months down the road, why didn't you tell me about this sooner?
Yeah.
You know? And so, you know, you know, again, or the cover up is worse than the crime. But yeah, I mean, I think that, and you know, if you think about the, you know, the Janicki logging case in our state, which is basically, it's a statute of limitations case, and it basically says the statute of limitations in a legal malpractice case against a law firm doesn't start to run until the relationship, the attorney-client relationship ends. And the policy reason behind that, in part, is because you don't want to penalize the client for sticking with the lawyer when the lawyer's had the client come in the lawyer has the client come in the office and so I messed up but I can fix it. Because what the court is thinking there in that case, thinking that there's nobody more motivated to fix the mistake than the lawyer who made it. So on that end of things, the statute of limitations, you know, you say, you know, give me a shot, I think I can fix this. The client has, you haven't hidden anything from the client. The client has notice and knowledge, and the client makes an informed decision. You say to the client, look, you know, go down the road and talk to somebody else to see if this is, if you're, you know, if it's fine for you to stay with me. And if the client gives informed consent, and you can tell the client the statute of limitations isn't going to run until I end, and this case ends, but let me handle the appeal, you know, and I'll do it for free. I hear this all the time, you know.
And your trouble in this case is going to be the client doesn't want to go see another lawyer. And if you don't almost force them to see it, there might be a question as to whether or not you've gotten adequate consent. You need to go through the consent process, and here's one time you really have to stress seeing another lawyer.
Yeah.
Or else the consent might not be found to be valid later on.
Yeah, I think that's true. But again, don't solve these things on your own. You know, get advice. You know, think about you know those emails being discoverable. And I'm out of time. You guys probably know about the Arden versus Forsberg and Umlauf case.
I'll cover that in mine too.
Okay.
So.
And by the way, I wouldn't have touched that case with a 10-foot pole.
Arden versus Forsberg?
Yeah. I mean, you know the facts of that case? the homeowner shot a puppy.
It happened my first year in practice. I had the exact same fact pattern.
What's your opening statement? Ladies and gentlemen of the jury, we're here because Mr. So-and-so shot a puppy. We wouldn't be here if he hadn't shot a puppy, but we're here because you shot a puppy.
Same thing. I mean, I was on a case.
I could win that case.
I had that case 37 years ago. The exact same fact pattern in Wenatchee. Mark, thank you very much. We are going to, and I've checked with Maggie, post your entire PowerPoint so that people here can get it. If you get the resend to Maggie, we'll post it.
Well, I've got one that's like 180 slides, and it wasn't supposed to cut off, or it was, but
well, Maggie will get posted, so the rest of PowerPoint will be available. I did want to point out, I wanted to emphasize something, and it's also going to be a segue to Colin. On this on the phishing things, it's no longer just emails. I got one yesterday on text, and I reported it to our system, but I got a phishing text, where if I had pushed on the attachment, I didn't, I would probably have infected my iPhone. So you have to alert your people, and by the way, I think this includes your family members. You know, anytime you've got an attachment, be darn sure you are expecting something with an attachment from exactly that source, or you basically do not click on it. Anytime it has a link to another website, unless you are expecting this, you do not click on it. And that includes your texts now as well. It's not just emails.
And Bitcoin is about $9 grand now, so.
Bitcoin's booming. Oh, it might be.
I suppose until I followed it more closely, if somebody come to me and say, you know, they encrypt our data and they say we need 3 Bitcoins, and I go, all right. Turns out, like until yesterday, it was like $33,000.
For 3 Bitcoins?
Yeah. It hit 11,000.
They used to be 50 cents.
I know.
Wait. As a segue, Colin practices in this area. Should you have the unfortunate need for an emergency response to a cyber breach, Colin's part of our cyber emergency team. And Colin and I are both in the Schwabe law firm. Colin is our assistant general counsel. That ranks above me being associate general counsel. Colin's my boss. And so I will hand off to Colin. One more thing about Colin's credentials, aside from being an excellent musician, Colin sits on that WSBA committee that is actually helping to generate those various opinions in the last few years that Mark was referring to. So if you have a question about one of those, Colin may or may not have contributed to that one, but he sits on that committee and he knows what's coming along and what they're working on next. With that, Colin's going to cover confidentiality. Do we have this powered back up yet?
I'm not sure how this is. I'm going to look to Maggie.
Maggie?
needs to push that button.
I'm sorry, what?
Do we need to re-push a button?
Oh, and that, there, okay, so
Thank
I
you,
just
Mark.
pulled out more.
My name's Colin Follen. My practice involves generally 3 areas: maritime litigation, insurance coverage, and data breach advice to companies that have hacked problems. When I'm not doing that, as Chris indicated, I'm Deputy General Counsel at Schwab, Williamson & Wyatt, so I provide internal legal ethics advice and loss prevention advice to our lawyers. This presentation today is really about our currency, that is communication with clients, some of the metes and bounds of confidentiality that might not be entirely intuitive and might have actually been things that people do periodically. So although I will ask for participation, I will not ask for any mea culpas. I, unlike Mark, I don't sue lawyers, so I just try to make things go smoothly and move on. As Chris indicated, I am a member of the WSBA's Committee on Professional Ethics, so if you do have questions about some of the recent ethics opinions that have issued in the last few years, I'd be happy to talk about those too. So we'll talk about...
Oh, and I don't mean to stand up here.
Oh, that's okay.
I'm just trying to get you.
Absolutely. So we'll talk about confidentiality, communications, both what's required and what's probably helpful as a risk management tool with clients, based not only on the rules but also just on experience with addressing claims. I'll say a couple things. Please do interrupt with questions as I go. If you have questions though, please keep them hypothetical so that you're not disclosing any client confidentiality of your own. And of course, as I like to say, let's play this slide from the beginning.
Plugging it in always helps.
It does. No, it's been my experience as well. Let's see if this works.
We've been having problems with the clicker.
Clicker's not clicking.
Oh, use the up and down.
Up and down.
Up and down, yep.
Okay. Oh, going all over the place.
1 second.
All right.
Did you say the clicker wasn't clicking?
It's not working. I think you need to, I think you need new batteries.
Okay.
I know, we're that way.
All right. So as I was getting into it, caveats. I'm not going to talk about the standard of care for lawyers. This is really about best practices or things to avoid if possible. Of course, I'm not going to be your lawyer just by talking to you about this. So do keep your hypotheticals hypothetical. And if you've got a problem, hire a lawyer. So we'll get into it with a hypothetical called the Great Deposition. And we'll talk about what we can and can't do with these. The hypothetical goes something like this. The lawyer takes a fantastic deposition of the plaintiff, absolutely excoriates them in the case, and the lawyer is able to settle a case in a very low amount because of it, this masterful deposition questioning, great planning, great preparation. And the defendant and the insurer were extremely pleased with the deposition and the result. They just think this is fantastic. The lawyer is also quite pleased with himself. So, the lawyer doesn't want to just move on to the next case. The lawyer wants to do a few things. First of all, wants to send the whole transcript to the defendant and the insurer, assuming that the lawyer is defending here in an insurance defense format. Let's assume no reservation of rights is in the case. As well as a prospective law firm employer, because lawyer, although they like their practice and they like many of their colleagues, they're looking for the next step in their career, and they want to show this good product that they have. They also want to post the transcript to a listserv comprised of fellow defense lawyers to share, of course, and maybe boast a little bit, and use portions of the transcript in a CLE, perhaps called the art of the deposition. And why not post clips of the deposition on the lawyer's website and have a link to Twitter so that all lawyers' followers can also get to this link and everybody in the world can know about how amazing the lawyer is and how this deposition was. So, we've got 5 or 6 different things the lawyer wants to do with this transcript. Are there any problems with this?
Tons.
Tons.
After point number 1, yeah.
After point number 1, okay, well, and we can, if people don't want to take positions, we can also just make arguments about it. So they want to send the transcript to the defendant and the insurer. Point number 1, we probably think that's okay. First of all, the defendant is the lawyer's client. The client's entitled to the file. This is part of the file. Easy. The insurer, in this case, lawyer probably at the outset of the case, said to the client, this is the nature of our relationship. In Washington, you are my client and your insurer is paying the bill. And I presume that you want me to keep your insurer apprised of the case so that they can settle it and continue to help you get out of this case. And the client probably said, absolutely, please do. And please send what you wish in your discretion. So let's presume that that's fine and that's been done. The answer is probably yes. Now what about to a prospective law firm employer? Let's also assume there's no court order, no protective order that says portions of this deposition can't be shared with anybody. Let's just say it was an ordinary deposition of the plaintiff, and there's nothing of that nature involved. Is that a problem?
I think so. I think you'd have to get consent, and I'd get consent in writing.
So I saw somebody say, no, not a problem. I'm hearing somebody say, yeah, you need consent in writing. Tease that out a bit. Why would you think you need consent in writing?
Because I think there's probably confidences in that deposition transcript, and you'd want to make sure that your client was advised and that they consented if there were confidences.
Okay, so if there are confidences found in the transcript, then you need client consent. Certainly, if client confidential information or client secret is somewhere there, that'd be an issue under 1.6, and we'll unpack the rule in a bit. Let's remember, though, the deposition is of the plaintiff. Lawyer represents the defendant. Lawyer really doesn't have an obligation to plaintiff, but you're saying there might be confidential information there because plaintiff is going to be testifying about defendant and its information relating to the representation.
So thanks for restating the facts, but I may have not been listening completely, but I still think I would still get consent because there's work product, your lawyer's work product, the way that the questions that are asked could expose some confidential information.
It's possible, certainly. What if we change the hypothetical a bit before we go on to the next point, and instead of it being the plaintiff, what if it's an expert witness that is a frequent flyer in plaintiff cases? Every plaintiff's lawyer hires him for some aspect of a PI case, and finally the defense bar has brought this expert to their knees. Any problem with that, sharing that with a prospective employer who also is in the defense bar? Some people are saying no. Some people are looking at phones and quiet and wondering what the answer is. Well, let's put a pause on that for a second because Colorado this year actually came out with a formal opinion that addressed depositions. So we'll get to that in a second, but let's talk about some of the other concepts first.
And Colorado is the same version of the rules we have in Washington, right?
Close enough. Yeah, the comments differ a bit, but the confidentiality rule is the same. Post the transcript to a listserv, so sending it out. Well, it probably doesn't make a difference if we could or couldn't send it to a law firm employer. Probably the same thing is true of a listserv of others because we're still dealing with people outside of that lawyer-client relationship.
I tell you, we're doing that all the time.
People do it all the time. People might call up a colleague and say, hey, I heard you had a case where this expert was hired. Can you send me this or can you send me that, right?
Exactly.
Can I phrase it this call? Has anyone here not received a request for a deposition from a case they've been on in the last few months? I have
on the listserv all the time.
Even beyond the listserv, I've gotten customized. I see you had this expert in this case that went to trial. Can I have the transcript? We get these all the time from around the country, right?
Yes.
Okay.
Right. In fact, some people would say that might be a method of getting new business. Use portions of the transcript in the CLE. Well, this is easier because now we're dealing with a slightly different concept. We're not talking about the entire thing, so perhaps it doesn't even reference the caption of the case. Maybe it's just this really good question and really bad answer that the plaintiff or the expert found themselves caught up in, and there's no identifying information of the client.
I see that all the time too.
See that all the time.
Yeah, it doesn't even identify who the witness is.
Right.
Just here's a good back and forth with a plaintiff driver or something like that.
Right. So an exchange, generic, couldn't be tied. In fact, it might be so generic and so bereft of any identifying information that you might view it as a hypothetical that you could come up on your own without actually using the real transcript. Okay. Now, what about posting clips on the lawyer's website? Post a link on Twitter. Heck, maybe it's a video deposition. That might get a little more complicated because it's going to be identifying the party. Well, let's get to the rule. So the Colorado Formal Ethics Opinion, in case you're interested, 130 came out this year, and it's a fairly lengthy one. And I'm actually going to just use a few quotes from it because I think they're pretty telling quotes, albeit a bit out of context. When a lawyer obtains a deposition transcript or video deposition in connection with representing a client, RPC 1.6 is implicated. That's our confidentiality rule. So if you have the transcript in connection with representation of a client, we're talking about RPC 1.6, and we'll get the rule up in a moment. It also stated there's no exception for revealing information for educational purposes, to assist another lawyer, or because the information is, quote, newsworthy. So though it might be interesting, though it might educate folks, and though it might help a colleague or somebody at another firm, that's not an exception. And those are quotes out of the Colorado Formal Ethics Opinion. They also went on to say, even if the deposition is filed, for example, I would say they say this: information relating to the representation of the client often is in the public record. So one thing you might want to say is, well, the deposition got filed in connection with a motion for summary judgment, so it's public record, who cares? That's not enough. They say there's no exception for disclosing information in public records, which is accurate. That's not one of the 1.6b exceptions. They also say, nor is there an exception for information that is otherwise publicly available. That is to say, if somebody else happened to put it on the internet, that doesn't mean that the lawyer can as well. Chris?
And that's expressly different from what the rules were like, say, 20 years ago.
Or at least practice.
I think there was actually, there was phrasing in rules 20 years ago that allowed otherwise publicly available as an exception, but I'd have to go look back 3 versions of the rules to find it.
Well, and certainly there's the, what about information relating to a formally represented client that becomes generally known? That might be one thing that people ask, and we'll talk about that briefly in a second. Another concept that the opinion made clear was that we should counsel our clients about what should be published before it's published, even during representation, and obtain informed consent. One example would be the things that a client puts in discovery responses are going to be handed over to the plaintiff's lawyer or the other side, and they might choose to do all sorts of things with it with their client's consent. Or they might be filing something in the public record, and although clients will recognize, yes, you're filing with the court, some less sophisticated clients might not realize that anybody can go get those files and do with them what they wish. Also noted that just redacting the client's name is usually insufficient, which makes sense because if all you do is take out the client's name, there still might be enough information to identify that client or allow somebody to figure out, connect the dots, this is who we're talking about, this is the matter we're talking about. Or, for example, if the caption, the case number was still there, that allows somebody to get there as well. So what about the generally known exception under RPC 1.9C1? That's the former client representation rule. It says you can't use information to the detriment of the client or otherwise disclose confidential information without consent or some other exception. One is if it's generally known. There's different cases. It's not a lot out there. And so my thinking on the subject would be, and I invite Chris, if you disagree or have other thoughts, would be that if it's in the public record, that's probably not enough. If it's in the Seattle Times, it's probably not enough. If you're disclosing something like, you know, Pepsi is a company that sells cola drinks, that's probably fine. Everybody generally knows that. But if you're doing something that is based on something in the public record, disclosing that simply and saying that's generally known, that is probably a risky thing to do.
What about the trick of, instead of disclosing it's publicly known, referring them to, you know, you can go look this up in the Times today. Or you can, I mean, what about referring them to what's publicly known with a clear inference that it's about your representation?
Can you give me more facts on that hypothetical?
Well, someone asks, what are you doing? Well, read Seattle Times page 3 today. Or what did your client say? Well, go check out the court file. So can I refer them to what's publicly known, where it's clearly about information related to the representation?
Well, I think the question would be whether the lawyer is making a disclosure of client confidential information. And if you're saying, here's an article that I read, it's probably different. You probably didn't get the article through representation of the client. However that information got into the article might be a problem, but the fact that you've got the article and you're sending that along alone probably doesn't do it on those facts. But that becomes a slippery slope the more that we direct people to things like, go check out case number this and this, docket number this, here's the client's deposition. It's pretty much the same thing that you're doing. Question?
Yes?
Yeah, if you're representing the defendant, the deposition is of the plaintiff, is the concern that there's a confidence pertaining to the defendant that's included in the transcript?
No. Good question. So the question is the concern that there's something about the deposition that the plaintiff says about the defendant that shouldn't be disclosed? It's actually broader than that, which is actually a good segue into the rule. So we'll just take us through real quick here, RPC 1.6a. So as we know, it's broad. Since 2006, that was when we changed the rule. We can't reveal information relating to the representation of a client unless they give us informed consent, or we've got some implied authority to make the disclosure. Often that we find this in discovery responses or motion arguments or the like. Or the disclosure is expressly permitted by sub B, which is the long list of exceptions that we're not going to go into and that are looking at things about harm and other things like that. Yes, sir?
Colin, I maybe jumping ahead, and we were talking about, and this follows up on that question, and we were talking about sharing deposition transcripts on a listserv. Quite often, it's a listserv I'm involved in. It's a asbestos defense website. And quite frequently at these depositions, there's attorneys for 5 or 6 defendants at the deposition. How does that affect this rule? If there are plenty, you know, sometimes they're clients, you know, you got 5 or 6 defendants in there. How confidential is this deposition still?
Great question. It's still confidential as to the people it hasn't been disclosed to outside the matter, because it's information relating to the representation. As you see, and by the way, it also applies to former clients, but as we see from the comments, it applies to disclosures that don't necessarily themselves reveal information, but could reasonably lead to the discovery of information by a third person. And we talked about the hypothetical exception. So you can frame things in terms of hypothetical if there's no reasonable likelihood that somebody can figure out what it's about. But to get to your point, it's broadly interpreted. It's not just confidences and secrets. Now, the rule before the 06 change referred to confidences and secrets, and Oregon, where I also practice, still has confidences and secrets as its definition for information relating to the representation. But here in Washington, we don't. Here in Washington, under comment 21, a confidence is just that information that's protected by privilege or applicable law, and a secret is the thing that you find out while representing a client that they've said, hey, don't tell the rest of the world this, or would be embarrassing or likely detrimental to the client. So confidences and secrets are much narrower in scope. But our rule, if we back up, is broad. It's beyond that. It's not just confidences and secrets. So we start with the proposition under our rule as drafted that what we learned during the course of representing a client all falls within that confidential bucket. It might be totally harmless to the client or not embarrassing to disclose, but the rule doesn't limit itself to what they say don't share, and it doesn't limit itself to what would be embarrassing. It's any information relating to the representation of the client. Now, how do we actually work a case without having to go to the client every time? Well, there's certain things that we're impliedly authorized to disclose. But when it comes to things outside the matter, our personal networking, marketing, business development, those things are not an exception. Yes, sir?
Yeah, so just so that I'm understanding from a practical point of view, are you talking about the client's deposition, or are you talking about the deposition of any witness in the case?
Any witness in the case. Any discovery response in the case.
Colin, I am totally confused here. We had, a decade ago, we had all this litigation and news coverage about the openness of our courts and how there shouldn't be sealing of court files and all that junk. And now you're telling me that all that stuff that cannot be sealed because it is presumptively part of the public record, including a deposition, we have to keep to ourselves, even though it's not privileged, not subject to a protective order, not nothing, and it's something the plaintiff has put into evidence at the beginning by just starting a lawsuit.
Yes.
That is in and of itself a waiver of the physician-patient privilege.
Of privilege. So let's unpack this, because those are two different things. One is the ability to seal a court record from the public. you're right. Once you put something in the public record, it's in the public record. We're talking about a different universe, which is the lawyer's ability to make a disclosure that is not falling within 1.6a. And the difference there is whether the lawyer can send to somebody else the client confidential information.
It's
Not whether lawyer.
Deposition is not client confidential information.
Actually, it is under 1.6a because it's information relating to the representation of the client.
For the last 10 years.
But I guess my problem is how is, so giving the deposition of an opposing expert to somebody, how is that, I mean, that rule so broad that that is information relating to the representation of the client? Is that what you're saying?
Yes.
Regardless of whether there's any confidence or secret or anything like that in there?
Yes.
Regardless of how many parties in the case?
Yes.
Linda,
So let's unpack the party deposition because that's a very good way to unpack it. You have plaintiff and 5 defendants in a deposition. You are, you would argue, and you'd be right, impliedly authorized to do what you need to do in that deposition to represent your client, to use the evidence, to ask the questions, impeach people with evidence. And you might also be impliedly authorized, say in a common interest agreement or joint defense agreement, to share information with another party through their counsel. People do that all the time. And so you'd have a great argument. You're impliedly authorized to do that. You're also impliedly authorized to file things in the court record, motions for summary judgment, declarations, testimony. And the presumption is all of those things won't be sealed unless you meet Washington's criteria for sealing them. Mm-hmm. What we're talking about is something outside of the lawyer's implied authority within the matter. That is the lawyer taking that same information relating to the representation of the client, regardless of whether it's been filed in the public record, regardless of whether an opposing party or a co-party has it, and sending it elsewhere. So say to the New York Times to increase your profile or to talk about your case. That's the thing that this rule contemplates. Now,
Colin, have you ever
yes.
seen a bar complaint?
Yes.
Okay.
I'm defending a lawyer now on a 1.6 issue.
Oh, and what was the disclosure? You can't say
I
disclosure.
can't. All I can say is I'm defending such a complaint now, it's not public.
Have you, in your, I've been practicing legal mel for about 10 years and been practicing for 17. I have never seen a bar complaint or a legal malpractice claim that has arisen out of this issue. And you have one now, but...
I have one now.
And,
So that-
how many in your career have you seen?
This is the first where they actually are talking about charges.
Yeah.
So who complained?
I don't really want to give disclosure,
Okay,
but I do want to say, you can take a look at what.
What
Mark put up
initiated
there,
the
and you can-
Colorado
You can
opinion?
infer from what Mark said.
It was the question, I mean, questions that bar committees get either prompt an opinion or they might say, this is something that we think would be helpful to the bar. I mean, that's generally what our CPE does. I can't tell you what the Colorado process was to issue this opinion. This wasn't about a discipline matter, it wasn't about agreements. There's a very easy issue, way to resolve this, because I can tell people are thinking, gosh, I really want to be able to share this information because there's going to be no harm to my client whatsoever.
Right.
Of course, recognize that some clients will feel that there is harm. Not every client's glad to be able to say, I was in litigation, I got sued, and here are the allegations. And some clients, and I can tell you this, will feel even more concerned about it when the source of disclosure is their own lawyer, their own confidant, their own fiduciary. It might not harm them to disclose something. You might have this great, in that hypothetical, going back to it, you've got a great deposition, you want to share it. It's very easy for that lawyer to go back to the client and say, you know what, this was a big win, and I'd like to tell people about it. Here's what I'd like to say, or here's what I'd like to do. And in my experience, when you've got a situation like that, the client can be quite happy to do that. They might not be. They might say, no, we have a policy where we really want you, you are our fiduciary, you keep what, we don't want you speaking on our behalf or providing this information, and that's their right to do so. But often, after a win like this, they might be willing to do so. Yes, Chris?
I have a specific question, and by the way, I want to point out that if has anyone here worked for Walmart?
Yes.
Because I think Walmart specifically prohibits maybe their stuff being shared like this.
I haven't worked for them in a while, so...
Okay, they used to.
But yeah, many clients will actually even prohibit you from
saying that you ever represented him.
I have seen, in the context of representing lawyers, engagement letters that prospectively cover this issue. And I wanted to ask what you think of that. And it would say right up front, at the initiation of the engagement, oh, by the way, we are documenting that you're consenting unless you object, or some prospective way, to our use of information related to the representation on our webpage, and exchanging information with the lawyers, such as depositions. What do you think about that at the outset of the representation?
Well, I think we got that question about 7 years ago when we did a seminar on social media marketing. Because a firm had asked about that, and I think had a letter, something that's vague in the back of my memory, but the issue is similar to what Mark was saying with advanced consent to conflicts. You're getting that at the outset of a matter probably is only as good as you're able to describe the very thing being waived. So it's probably pretty weak if it comes with your engagement letter, because the client will have no idea what it's agreeing that you can disclose. Having said that, if at the end of the matter, when you're sending a closing letter, you then seek to obtain, I'd like to disclose X, Y, and Z, or I'd like to say, give this description of your matter and put it on my website, may I do this? Then I think that's very different. I think you've got, with that post-matter consent, that's probably pretty good. Whereas if it comes at the beginning, it's probably too vague and uncertain to really to hold up. Yeah.
So just to take the theoretical and apply it to practice, so you're saying if I get a listserv inquiry that says I'm looking for the depositions of expert John Smith, and I've got 4 depositions of John Smith from a case a few years ago, I should not provide that deposition without first getting my client's consent?
The rule says that you want to get client consent, because after the matter, because it's not part of the matter, you're sending it outside of that, and you're not impliedly authorized to do it. So you'd want to get consent to share it.
Okay.
Now, practically,
so where your client was involved.
Yeah.
What's that?
If your client wasn't involved in one of those 4 deps, you can send it. Only as to the case where your client's involved.
No, it would be to anybody in the matter.
Yeah.
To anybody in the matter.
Even if you don't have a client in that case.
Even if it's not the client's
Sometimes I've collected depositions on people, and for other cases where my client's not involved,
Okay.
I can disclose those.
Well, that would be information.
Oh, no, wait, you're saying
That
you've
would be
already gotten
information
these from other
Somebody
people.
from somebody
You've
else.
already got a library from other people.
Dozens.
You're not the person who owed the duty.
Yeah, right.
Yeah, my client wasn't involved in the case.
If you wanted to be highly theoretical, one could say, well, if you gathered those depositions while involving A versus B, you gathered them while representing C, C has to consent. As a practical matter, that's probably not going to be something that C gets terribly upset about.
Right.
As a technical matter, C would consent, would need to consent. But the problem that we have with this is that this has nothing to do with the client being harmed by the disclosure. The rule doesn't turn on client harm.
Right.
Even though, oh sorry, but if you're collecting the deposition transcript of Bill Parton over 10 years and you use it on a new client, I'm not showing my new client the 7 deposition transcripts of Bill Parton.
You're not disclosing it.
I'm not disclosing that to my client, but I'm using what I've acquired during my years in practice.
In that case, you're not disclosing it.
So
The rule prevents disclosure.
Yeah.
Yeah.
But to use the Bill Parton example, I know of someone, in a situation like Bill Parton, who decided between cases, I'm fed up with that expert. I'm going to collect every deposition I can and have them available to me. You could make an argument then that that was not information-related representation because you did it on your own time. But if you paid your time on a case to collect those 10 depositions, it's information related to the representation.
I got to believe the common practice is contrary to the rule. I mean, really. I mean, all these listserv requests that we get.
Yeah.
And you may be right, and it might also be correct that generally, even if clients find out, they might not be upset.
Maggie needs to shut down the website.
Yeah,
Well,
so you need to.
Well, no, we need to get permission. There's a difference.
Yeah.
All we have to do is ask permission.
What's been the bar's enforcement position on this? Because I agree, this interpretation of 1.6 has been around ever since the ABA changed the models. and it hasn't taken hold with the bar as far as I can see. So I'm kind of, let's get practical. What's the enforcement position of the bar?
Well, I don't speak for the bar, so I can't say.
You represent lawyers to experience it.
No, I don't represent lawyers now before the bar. I don't do that anymore.
So nobody knows.
No, what I would tell you is this. We're talking about two different things. One is what the rule says and what it accepts. And those are express.
Yeah.
And what we're also talking about is, well, what's the likelihood of harm to me or to my client? And those are two different things. And what is the likelihood that somebody will file a grievance against me?
That's something here who works in the public sector. So it's unfortunate Mike Nisarowski was in and left. But I know that the state AG's office is required to turn over deposition transcripts under the Public Records Act unless they're subject to a protective order. It doesn't matter whose depo it is. And they went to the bar to try to avoid that, because there is an exemption in the Public Records Act for matters that are privileged or work product. The court's overruled it. So, and I don't know how nuanced that argument was lost years ago. So be curious to know, because they still have to turn these things over. I mean, the plaintiff's bar minds that office like mad.
I can't speak to public records law other than to say there are three types of secret stuff: attorney-client privilege, attorney work product, and client confidentiality. And so, yes, as my very limited understanding of public records law works, privilege is an exception to those disclosures. Work product, I couldn't tell you. And I think what you're touching on here is client confidentiality, and it sounds as though there's been some statutory requirement that prevents the client from asserting that very confidentiality in terms of the state.
I think the argument that the AG would make is you can't compel me as a member of the bar to violate the RPCs. I know that was the argument that was made and lost.
And that's a good argument. Yeah. So one of the questions that comes up is, because I think I heard this with Mark, is how long does it last? How long does confidentiality survive? I think somebody asked about how long do conflicts survive, which is a great question. And it's pretty long, assuming that a client doesn't say, go ahead. If they give informed consent, confidentiality obligation to that thing consented to is gone and it's open season, provided that you had a broad enough agreement. But it does survive getting fired or firing a client. So closing the file or being fired doesn't do it. Nor does the death of a client terminate confidentiality. Oregon has a slightly different rule for certain estate and other issues that Washington doesn't have, and for any of you who practice in Oregon. But generally it survives a very long time. So if you wish to share, some things to think about are, first, is the thing I'm going to share affected at all by a court order or a stipulation of confidentiality, protective order? Do I have some law out there external to me and my client that's preventing me from doing this? So that's one question to ask. Another is then to say to the client, here's what I'd like you to do, here's what I'd like to do, disclose this, here's why, here's the risks and the benefits, and what kind of talking about what you're going to use it for, and alternative options. That is to say, client, you can decline, you don't have to say yes. And sometimes that's a hard thing to hear, like when you want a great trial and you want to talk about this result and the client says no, keep it secret. But better to at least have that conversation than have the disclosure and the client find out and then have a problem. Also, consider redaction. That's something, if you go back and read the Colorado opinion, they did talk about, heavy redactions might do it. Depends on what's being redacted and what can be found out. And I'd also suggest, though it's not required, that if you are proposing to write up something about a case that's not simply reporting on a reported opinion, but talking about something outside of that, that you memorialize it in writing. It's not required, but it would be recommended so that that client, if they ever forget that they gave you permission to talk about this case or go on CNN or what have you, that you can say, no, remember this email exchange we had, you agreed to this.
So can I send my client an email saying, with respect to the 87 cases I've had with you, do you have any problem with me sharing any of the deposition transcripts from any of those cases with my defense colleagues?
If I wanted to support that, I'd say you're dealing with a very sophisticated client.
Yes.
Who, if they have the right to waive that, if they're confident to waive, you've got a sophisticated client. I would argue in favor of that. If I want to argue opposed to, I'd say that's so darn vague that they don't really know what they're agreeing to. And then it's a matter of what, I suppose, if they went to a grievance, a hearing officer would say about it. I'd err on the side of specificity, but you know, it's a circumstance-dependent question. Certainly, if after a matter's closed, if you have checklists for your matters, you know, when you send the closing file, you might think through, is there any publicity I'd like to get from this? And should I seek consent? Or were there some good deposition transcripts that I'd like to use in the future or send around, bragging myself? That's really the perfect time to do it and to get that consent. Yes, sir?
Does this also apply to reporting cases to the companies that do jury research? Yes. So you're talking about post-matter, you tried a case, and then a jury verdict service says, tell me about the case? Yes, same thing.
I have for years run those by the client because I don't want the client to read something and think that we wrote it without the client getting a chance to prove it first.
Right. Yeah. Plus, if it's a good result, you could say it's kind of a nice marketing opportunity to say, hey, remember this good result we had? I'd like to write this up. How do you feel about that? And then the thing that will last with them was, yeah, you did a really good job for me. That'd be fantastic. But yes, now, when I first heard you talk about a jury, I thought I heard you say consultant and you didn't. If you're representing a client in a matter and you want to go get a mock jury or, you know, do one of those tests before you go to trial, you're probably not having a problem because you're impliedly authorized for that client to do that, or at least you've talked to the client because that's going to be a pretty big item on the bill. So those are some steps to take. There are probably more that you could think of, but again, if you want to do that outside of the matter and you don't have implied authority, consider doing it at the close. Mark went into a hypothetical that I like to get into, and I want to talk about this one practically, which I call unsend. And that is, the client emails the lawyer asking for an updated case analysis, including how bad does it look and how much is it going to cost. The lawyer gives a very thorough response, providing every bit of detail requested, as well as, can I have X dollars to settle the case because you don't want to take this one to trial. So the lawyer, of course, intends to send the client and lawyer's paralegal, that is named Jonathan. Lawyer blind copies self, which is lawyer's practice of doing so, to then save the email to the file quickly. Unfortunately, lawyer's email program thinks that lawyer wants to send to Joseph, not Jonathan, and it goes to Joseph, who happens to be opposing counsel. And once that BCC copy hits the inbox, lawyer freaks out. I love Mark's hypothetical, which is really the same as this one. But my question is not what went wrong, but what should lawyer do in this circumstance? Something's already happened. Mark gave us a hypothetical. Well, he's self-disclosed to the bar, so what's left? This happened to you, what would you do? Or what would you recommend if your colleague came down the hall and said, my goodness, help me?
Well, number one, I would immediately notify the improper recipient. Probably number two is I'd notify the client. And then number three, maybe I'd notify my malpractice carrier.
You stole my slides. So the first one, yes, absolutely write to the recipient immediately, which this is always a reminder that if you send really important emails, maybe consider sending them at the beginning of the business day rather than at 5 p.m. So you can actually get a hold of the recipient. So notify them, hey, I did not mean to send this to you. Perhaps in an email that says read this first, or if you've got some other method, text if you know this person well. Say, I just sent you something you should not have received. It's highly confidential. Please delete it and tell me that you did. Request the deletion and written confirmation that they did. And then also call them if you can, consistent with the writing, and have a telephone conversation. Without disclosing any client confidential information, one hypothetical might be you send a settlement request for settlement authority and exposure analysis to your opposing counsel accidentally, who happens not to be in the office because they're out mountain climbing. Well, the writing wouldn't do much good because their secretary or paralegal might pick up that in the inbox, but a phone call might do it, so call them as well. Basically, everything you can think about doing to get to the recipient, you ought to. If you use some programs, you might have a recall this message. If you know technology, you know this really does absolutely nothing. but do it anyway, because if it does blow up and you do get deposed, at least you can say, you know, I did everything I could. I even tried to recall the message. It didn't work. So, and then also, if you hear nothing, or if somebody says, no, I'm going to hang on to it, consider whether to seek a protective order. I will say, in the experience I've had helping people with this, I have never yet seen a lawyer push back. I think it has something to do with, that might happen to me too, good karma. Chris?
I have.
It used to a lot more. There's been a clear trend, especially in the federal courts, in favor of clawback. But I can tell you, when I was on the RPC committee 25 years ago, half the room said, no, you have a duty to use it to the benefit of your client. So
And read it.
There's been a trend away from that, but that has existed for some time as a contingent.
And I'd also submit that under most court rules now, if there is an assertion of privileged and inadvertently sent information, the obligation of the rules is to sequester it. And then you get a ruling before you read it. So I'm sorry to hear that you've had that experience. I think that position is...
Give the details, but it was a document inadvertently disclosed in discovery.
Mm-hmm.
And the party that received it kept using it and papering the file with it repeatedly. It was like a virus, you know. And it was eventually the court did rule in our favor, and you know that attorney was removed from that particular attorney was removed from the defense's case.
Disqualified. Yeah.
Well, he was counseled to remove himself. Yeah. But it was the most blatant situation I've ever seen, because I never had that problem.
That's
And mine was, it turned into the settlement of the case. It was the main thing that settled the case. So it was a big deal.
It can, and in which case that's the other important point. You might need to notify your client and your malpractice care if that's the case, because in that case, there's a good argument that communication might have been a negligent transmission, and that it actually did cause the client harm because it said, here's what we're willing to settle for.
I have one other practical piece of advice, because autofill is what we're talking about.
Yes.
We love autofill. It's incredibly dangerous. I periodically, about once a month, actually go through my autofill, put in the common names, and delete out the ones who are opposing counsel. So I still have inadvertently sent emails, but they tend to go to within my law firm. So a caller might say, did you mean to send me this? But they don't tend to go outside the law firm, because I'm going through my autofills, the common names, and delete. All you have to do is hit delete, and it removes it from the autofill. So when you put in John, Joe, HN, and all these numbers show up, you don't want some of those people there, click down to that and delete it.
Until the next time you send it.
Well, yes, the thing is you have to do this on a regular basis.
And I think Mark's practice is a good one. I've advised that as well, that when you're composing something important in an email, start with the body, get everything composed, work backwards up to the addresses, and I like to read them out loud to myself about 2 or 3 times. That makes sense. So those are some things to think about. I would also say, this sounds silly, but it's happened, that if you get to this situation where you have to seek a protective order, remember, you don't want to file the thing that was inadvertently disclosed in the contract. I know, but it happens. So, okay, I want to go through quickly communicating with clients just because that was part of this, but then I want to jump to withdrawal. That opinion that Mark talked about is a pretty important one, and so I do want to talk about some of those points. Really, it's the art of managing expectations, but the first part is what we're required to do. Keep the client reasonably informed about the status of the matter. Sometimes it is easy in an insurance defense context for us to notify the insurer all the time and not the assured, but really both of those, even though your client is the assured, so the assured needs to be informed about the status of the matter, and promptly comply with reasonable requests for information. So you don't have to respond to every single request for information from a client, but you do have to respond to reasonable ones. And explain the matter obviously reasonably so that they can understand it. I'm seeing clients more and more wanting to communicate through text messages, and I'd submit that that's probably not something that you want to do for 2 reasons. One is they're not that easy to archive in a way that is good for metadata and the like. There's some programs out there I've been told, but that's just not easy. The other one is it's not a medium that's conducive to really in-depth discussion of pretty much anything. So try to avoid that. I wouldn't say, it's not dispositive, but I'd say it's not something that you want to, medium you want to use frequently. Also, of course, if there's a decision that they've got to make, that they need to make informed consent, they need to know so promptly, reasonably consult with them about their objectives, and consult with them about any limitations on your ability to do something if they think that you can do something like, say, lie, cheat, steal, or obfuscate in a way that is inappropriate to the rules. Those are the requirements. The other pieces, just practically speaking, is managing expectations. Sometimes you might have clients that have specific reporting requirements, and you might have other clients that don't have specific reporting requirements, but you know that they're very difficult to manage. And thankfully, I think the plaintiff's bar has more of that than we do in terms of difficult to manage client expectations. They're always calling and that sort of thing. But if you find that you've got clients who are problematic in that regard, consider putting in your engagement letter how you're going to handle client communications. You know, I'm going to report to you, I'm going to plan to report to you regularly on this kind of schedule. And if there's something else that comes up, I'll let you know. It's about setting client expectations. So sometimes that can be helpful. Obviously reducing misunderstandings. And if clients made a decision, those communications, if in writing, can help lawyers defend you. When the times that I've defended lawyers, I don't anymore, writing can be very helpful. And it reminds the client that you're working hard for them. For those of you who have handled legal malpractice cases or seen mock juries or hopefully not have been sued, you will recognize that jurors think that we write everything down. They just do. And they're wrong, but that's what they think, and they're not going to be disabused of it. So the more that you can reduce your writings, reduce what happens to writing, the better it is for you. That can be the client communication, that could be a note to the file, that could be something in a billing record if need be, but those are important things to do to manage those client expectations. Because I know I'm running short on time, I'd like to jump through
You have 10.
a few, what's that?
You have 10.
Yeah, I know. I'm going to jump through here to a few. You guys know these. All right, the bad client. Lawyers hired by ABC to defend it in a tort case, and the corporation provides an advance fee deposit to be drawn on at the end of every quarter. So we've got quarterly billing, and the AFD will be drawn upon the fees to pay the fees each quarter. The president of the company sits for a deposition, and after the deposition, the president tells the lawyer that he lied about the presence of certain relevant documents. I didn't really want to tell them that. They're not relevant. I don't think they're relevant. They don't need to know about them. Lawyer says, you've got to correct the testimony, but the president refuses. The president also said that the company alone is going to conduct its privilege review of documents to provide discovery. So rather than give lawyer all the documents, president's just going to say, we're going to do our own privilege review, and we'll send you all the non-privileged stuff. Defense costs are high. It's a well-fought case, and the advance fee deposit gets depleted quickly just after the second quarter of litigation. So realizing that life is too short for this, lawyer decides, I need to withdraw. In this case, the court rules require a motion, and of course we're dealing with a corporate defendant, which is not always easy to withdraw from unless you've got substitute counsel. Usually possible. So lawyer's upset and seething. Lawyer would like to state the following facts in the supporting affidavit. Number one, ABC hasn't paid our legal fees, and they did not replenish the AFD as required to by the engagement letter. Without identifying the actual lie that President made in the deposition, lawyer wants to say President lied in the deposition and will not correct the testimony or let me do it. I'm not going to tell you, Judge, what they said, just they got it wrong and they knew it. And, Judge, they're not letting us evaluate the documents for privilege. Okay? So first question is, under that hypothetical, does lawyer have to withdraw? Obviously, lawyer wants to, but must lawyer withdraw, ought lawyer withdraw. Chris?
Well, I would say the lawyer, once the lawyer has counseled the client to correct a known falsity and the client refuses, the lawyer is obligated to move to withdraw. I say it that way because I've had this situation arise in federal court and had a court deny my motion.
Yep.
And I moved to withdraw, making it clear that there was irreparable differences about how the case was to be conducted in a date when a little bit more noise was allowed than now. But
that's
we'll
right.
have to move.
Lawyer might not be able to, but lawyer needs to try, and really try, not just phone it in, so to speak. So lawyer needs to withdraw because in this case, lawyer knows that the client has made false testimony, and where a client makes false testimony won't correct it. Our continuing representation is often held to be a perpetuation of that false information. Now there's criminal context that we're not talking about here today, just civil liability, but yes, so lawyer has to file a motion. And now the question is, what can or should lawyer say in the affidavit? Now Mark gave you a preview of it without really going into all the depth, but what do you think lawyer can say? And we'll go back so we can see the 3 things lawyer wants to say. Can lawyer say they failed to pay the fees?
I think so.
Think so, maybe. Why do you think so?
I don't see it as being communication or technically confidentiality.
Okay. Okay. How would you argue against that if you had
I was going to say, historically there was case law saying that failure to pay fees was a basis for withdrawal. And I think there's even some cases around the country that suggest that the fees themselves may not be confidential. I'm not sure I agree with that case law. In some cases, whether or not they're able to pay the fees might be information that is material to what's going on in the case and might change the conduct of the case. So it could be, the other side's going to move for a receiver because of that. So it could have a situation where it could disadvantage the client. And the act of withdrawal must be done in a fashion that minimizes the disadvantage to the client.
So we're talking about harm there, whether that communication harms the client. I think there's a good argument that that is problematic because the client's non-payment of fees you learn during the course of representing the client. So it would fall within 1.6. Moreover, it might be harmful to the client. Either they might seek a receiver, or they might look bad, or opposing counsel might say something bad about them. It might be embarrassing, detrimental. Some judges might say that's fine. They might not raise an issue about it. Others could. And I think there'd be a good argument that could be problematic. What about this one? This is a little bit more difficult. Without identifying why, they've said they've lied.
Well, that's a privileged communication.
Yeah, well, that's true. The lawyer's saying they lied. How does the lawyer know that? Well, probably a privileged communication, or at least some confidential information was used to say that. Regardless, the lawyer is calling the client a liar, and so that's going to be certainly embarrassing or detrimental. So if lawyer came to me and said, "Can I put this in an affidavit?" I'd say, "No, don't put that in an affidavit." What about this issue about evaluating documents with privilege? Judge, client said I can't do this. Privileged.
Exactly.
No. And confidential. Right. He said it. So none of these things, as a lawyer wants to, we'd advise them to say. But before we talk about what should be said, let's go through some of the points of the advisory opinion that came out. It said, acknowledge the obvious, first of all. Difficulty may be encountered if withdrawal is based on the client demand that we do something that we're not supposed to. And of course, it recognizes judges might ask us for a lot of information. I've seen this on more than one occasion where a motion to withdraw with an affidavit that's very bereft of anything at all is met with an order to reconsider with more information for the basis of withdrawal, say in federal court. So they might say, you need to tell me more, counsel, about why you should withdraw. But the lawyer recognizes, I can't tell you these facts that would constitute the explanation you want, Judge. That's out of comment 3. Lawyer's statement, this is actually out of the comments, which is helpful. It gives us essentially what lawyer can say, which is very limited. But it says, the lawyer's statement that professional considerations require termination of representation ordinarily should be accepted as sufficient. And if somebody comes to me and says, what should they put in the affidavit? I would quote, professional considerations require termination of representation. Because in that, you're not actually saying anything specific. There are a lot of reasons that a lawyer can withdraw from representing a client. You haven't said they're a liar, you haven't said they haven't paid your fees, but you said, I need to because of professional considerations. It's probably the quietest of the noisy withdrawal. Now, the comments also note that we should be mindful of our obligations and the court. So we've got these competing issues of candor to the tribunal versus client confidential information. And I would say that there are some judges who
think that 3.3 trumps 1.6, and lawyers who say the opposite, and I think the latter is probably more accurate, that our obligations of confidentiality prevent us from making those disclosures to the court unless we have some certain things happen. So, opinion 201701 came out this year, advisory opinion, and they are just advisory, they're not authority, said lawyer may always voluntarily inform the court that we believe there's a basis for withdrawal or that we believe that professional considerations make it appropriate for us to seek withdrawal. We can always say that. The opinion also went on to say we can also make similar statements provided that we don't disclose the particular reasons or basis for withdrawal. So in this case, the lie, the non-payment can't be disclosed.
So Colin, I know you sit on the committee that just produced this, and I know that historically a lot of the case law and precedent predates the current set of the rules, such what Gene was talking about. I think it was standard to say, I'm withdrawing because I wasn't paid. I think that was standard historically. Was your committee intending to make it a less noisy process when you promulgated this opinion?
To make it a less, no, because the committee doesn't have jurisdiction over the process,
well,
or really of anything other than to be advisory. But I think that, and I don't remember the impetus for the opinion, whether it was from an inquiry or from just the committee, but I think the goal was to help remind lawyers this concept of a noisy withdrawal is not something we can do, that we really do have to err on the side of not saying much, and recognizing that lawyers might be ordered to disclose information, at which case, and you'll see this if you read the opinion, the client might say appeal or require you to appeal, or you might have a reason to appeal that order. But they did say you can always state without violating the rule, and due to your obligations, you can't say much on the record, except you could do so in camera if the court requires. So you can volunteer to the court to take you in camera, but even then, I think you want to be as narrow as possible in the information that you provide.
If you're not paid, can you tell, if you're not paid and you transfer a file to somebody and the client says you can talk to that new attorney, tell them everything you know about my case, can you tell that new attorney that you weren't paid?
If the client has said you can tell my new lawyers everything,
everything
yes.
You know about my case, and you're not clarifying, can I also tell them that you didn't pay my fees?
I see. What does my case mean? Is really what you're asking.
Or is that, I mean, I've seen the former lawyer send the bills to the new attorney, and that's a way of handling that. I don't know, but have you addressed that issue?
I've been lucky enough not to have to deal with that. What I would suggest, though, is that if there's doubt about the scope of what the client has authorized you to say to the counsel, to compose a letter to the client that memorializes what that consent was and how you interpret it, so that you can provide that information and give them a window within which they can respond. So that is to say, if client said, send the file to my new lawyer, answer any questions they have, provide them anything, I would probably say it's helpful to follow up and say, okay, client, you've told me that I can make any disclosure to your client about my representation of you. I will provide them the file, answer any questions that they have, and give you them an overview of our representation of you. And you've sent them a letter that has a time frame. Let us know if I've got any of this wrong. At least you've got something that documents that. Now, a client might say, no, I never said that you could tell them that you didn't get paid. Of course, you might have an attorney lien that makes that knowable anyway, if you're perfecting a lien, but I'm not going to get into the fee lien laws. Yeah. Out of time. All right. So I will close with saying this. Read the opinion if you can. It's what if the lawyer is ordered to say more by the court? Read the opinion. You might come away with a feeling of, boy, it's circumstance dependent, and that's true. It is. All of these things are. But I guess at bottom, if there's a question of whether you can disclose something relating to the representation of the client, ask and get the yes or get the response, and then go from there, because at least then you've got it, memorialize it in the file, and we can all sleep better tonight. Thank you very much for having me.
And he speaks too fast. Okay, we are going to give Kristen the floor.
Dissident, which is.
By the way, don't forget our vendor swag in back.
Yeah, don't forget the vendor swag.
Thank you all for being patient. I'm Christopher Howard, you know that. Colin Folon is a tough act to follow. Interestingly, just as a way of introduction, I started getting into defending lawyers accidentally because I volunteered to be on the Rules Professional Conduct Committee 30 years ago. And then about 11 years ago, Colin came to me and said, you know, the rules are all changing. And that's when they adopted most of the changes, like no longer being confidences, secrets being information related to representation. And so we decided to not give one seminar on it, but to give a regular series of seminars, 6 to 10 times a year for the last 11 years. But it's amazing how many of our practices, like the ones on sharing depositions, got established under the old rules and didn't really change when the rules changed. And that's, I think, an example. I'm here to discuss conflicts today. I will actually be hitting some of the things discussed by the two prior speakers. I want to point out why I am going to be covering so many basics. I represent a lot of lawyers. I do a lot of loss prevention work for lawyers inside and outside. I am the outside conflicts counsel for several law firms of varying sizes. Some of these questions may seem obvious, but I keep getting asked them. So I figure I should cover them. As with Colin's presentation, we do not state a legal standard of care. Sometimes when people are suing lawyers, they ask, what conferences did you go to? They then subpoena these PowerPoints. Disclaimer is here to protect you in a future malpractice action, should there be one. Keep your, de-identify the hypotheticals. Okay, we're going to cover a bunch of basics and highlight frequent traps for the unwary and at least a few of the recent developments. I am going to try to speak fast enough to get to one of the cases that Mark said he was going to cover, but we are going to cover. This is the first of 2 pages of the basic conflict rules. The question that you asked early on, we're going to address at least quickly in RPC 1.9. But 1.7a will get the most attention. That's the concurrent, direct adversity, material limitation, and personal interest concurrent conflict rule. Business with clients, not just A, but a number of the 1.8 comments. These come up frequently. Colin's already covered most of the confidential information and the ramifications of not doing this. What the usual ramification I try to frighten people with, which I guess as insurance defense counsel, but for self-insured you would, but for others, the worst case scenario working in a law firm is disgorgement. In other words, you have to pay your fees back. It's not being sued, because usually when you're sued, that's covered by your insurance company. Grievances, most of those actually are manageable, and once again may be covered by your insurance company. But when you face your compensation committee and explain why you had to write a check back for $200,000 because someone didn't check the conflicts, that's usually the worst scenario for any lawyer who's expecting to get paid. Damage to reputation, you'll notice we didn't tell you what firm was involved in some of these law firms when we got that opinion disqualifying a law firm. It might hurt reputation, but for the most part, forfeiture and discouragement is what people fear most. We're going to cover this a bit in this room. Third-party payor. There's I practiced, I must admit, for a few years before I was even particularly paying much attention to this in an insurance defense environment in the 80s. And by the end of the 80s, I was certainly aware of it. Subsequent adverse representation in related matters, which is 1.9. And prospective clients, because some people who haven't read the new rules carefully may not be aware of this relatively new rule. Is there anyone here who took the bar in the last 10 years? Okay, you're aware of all the rules. When I took the bar, we didn't have RPCs, we had the canons. Yeah, I'm that old, and there have been at least 3 major different versions of rules for me to deal with. this is something that is relatively new for us, the prospective client confidentiality, and there are special things to handle with that. Okay, I am covering concurrent conflicts. Before I came here today, the majority of my day was spent clearing conflicts for me and for other people. That was the majority of my morning, including explaining to people what concurrent conflicts are. When there is more than one client who are adverse in one particular case, even if we don't represent, hopefully in the same case, they're in unrelated cases, that's a concurrent conflict with a risk that must be cleared. I keep having people saying, but what if they're not really adverse yet? Anyone want to give an answer to that? You still address it. You can foresee the risk of a conflict. It's best to address it before it ripens into, bad words and ill will. Addressed up front, even if it's a potential client, best address it up front. I have highlighted materially limited, not because I knew what Mark was going to say, but because this is the growth area for lawyer risk, the material limitation, the versus law type scenario, which indeed I think Mark was being optimistic under the rules of versus law. In Washington, if you are in a potential adverse situation to your client, the language of that opinion, while not crystal clear, suggests you are effectively, ethically not allowed to assert attorney-client privilege if you are materially limited in your representation because of your firm's own self-interest. Obviously, Mark and I could take different sides and each argue both sides of that, but their material limitation is the growth area for risk for law firms. Okay, yes, I say yes. This is the point I keep having to tell people. We represent A over here in land use. We represent B on some fisheries matter. A and B are adverse in this case, and we're asked to represent one of them. That is a concurrent conflict. Why am I hitting this so hard? Because it seems I have to teach people this every week. All over the city. People seem to think, but they're unrelated. That's a concurrent conflict. It should be waivable. It should be easily waivable if your clients are mature adults, and if you approach it early and appropriately. And it's also most easily avoided if you carefully define the scope. You can even define scopes to avoid or define away conflicts, and that's allowable under the rules. You can define your scope so narrowly. I have represented two parties in the same litigation on more than one occasion by specifically saying, we do not represent either of you with respect to any claims you have against each other, any disagreements you have each other, and both of you sophisticated clients with in-house counsel signing this agree that all of that is outside the representation. So you can define away conflicts with scope with a sophisticated client or someone who's sent to a separate counsel if you define your scope carefully enough. But normally, in the absence of getting such a close definition, if they are adverse, even if you represent them unrelatedly, you need to get a conflict. Examples. Now, the rules in the comments. Who here has read the comments to the rules? Good, someone has. You know what the frightening one is? There's a rule, comment 6, that says that you may have to run conflicts when you are taking discovery that may be of clients. Now, really it's narrower than that. If I have to adversely cross-examine you, and you're a client in something else, I may have a material limitation. Now, when I'm sending a subpoena for medical records to a hospital whose medical records department is making money off of selling me those records, I don't run a conflict check. When I send a subpoena to a hospital asking for peer review privileged information, I run a conflict check, using that as a more extreme example. As a general rule, if you're seeking employment records, seeking anything that entity might want to resist or fight, it is wise to consider a conflict check. In reality, many firms, I'm talking about people other than my own who come to me for advice, say, yeah, they were really annoyed to get this letter and subpoena, and they said, that's from our own firm. If nothing else, it's good business practice. Buyer and seller in business transactions. But this is an interesting rule Colin and I have carefully reviewed. If it's purely a matter of money, and we have some examples, there's actually authority that says economic adversity alone is not a conflict. That is to say, if it just comes down to representing competitors, Coke and Pepsi, in unrelated litigation, that does not normally relate to a conflict of interest scenario. Coke and Pepsi would not agree with that. They would both say confidential information gets in the way. But by itself, it does not generally create a conflict. Okay, material limitation, we've covered it's the growth area. And it particularly includes when the law firm or the lawyer's interests may be involved. The clearest example, are any of you in firms that have business practices also?
Yes.
Okay. Business practice, they wrote the contract, they sent it to you to litigate. That is something which now you should disclose, you should consider disclosing and getting an advance consent, because if it turns sour, you can be set up by, Brian Wade or another one of the plaintiff's counsel saying, didn't you realize your firm had a self-interest in defending that contract, as opposed to saying maybe the contract was done wrong? So your own, it's your firm's own work or fixing a mistake. I'm going to say something that both Colin and Mark addressed. I'll use a different term when I'm advising lawyers and they say something went wrong, and it's not something we can fix immediately. The next person to call is usually the client, because the way I phrase it is, this is one area where stinky things don't get less stinky over time, they get stinkier. And it's amazing how frequently, when called immediately and documented, when called immediately, the clients take the position, thank you for letting me know, thank you for keeping me in the loop, I understand, and you are the one to fix it. And then you document how you advise them to consider getting separate counsel regarding who should fix it. If they didn't know about it, as in versus law, things are just going to get worse. Examples of material limitation. This happens all the time in business companies. The three of you come to me wanting to form a company. Who's my client? Well, it's often written up as all three of you and the company. There could be a material limitation when one of you asks for something slightly different. We frequently see that scenario when people haven't sought the advice of general counsel first. Other fiduciary responsibilities, serving as a trustee, serving as a personal representative, which I'm doing now and I advise people against. It's not fun. Other employment, family member involvement, and the one I need to hit for everyone in this room, payment of fees for a third party. I am not going to ask for a show of hands, because I did this once years ago when I asked how many of you actually sending consent letters to insureds to document that they consent to payment of fees for a third party. I'm not going to ask that question. I'm of the opinion it is not universally done yet. It's easy to do. Historically, I know when I was still working in a pure insurance defense environment, the first thing I did was send a, hi, I'm your lawyer letter. All you have to do is put it right in there. By the way, your fees are going to be paid by the insurance company. If you have any problem with that, call. This is one of those areas, and I'll have a slide later, where your consent actually does not have to be in writing, just as use of confidential information consent actually does not have to be in writing. But remember what Colin said. Jurors expect lawyers to document everything. So if we haven't made notes of the conversation, it's best to document the consent in writing, because that's the expectation of our practice in the jury's mind. Okay, 1.9, that's the former client. You asked how long the duty for conflicts and the duty for confidentiality goes on. For the most part, forever. However, under 1.9, your primary limitation is work on the same or substantially related matter. As time goes by, that becomes remarkably remote. There's a secondary limitation I'll get to. You don't need to reach out and get consent unless certain things are going to happen, one of which is it's the same matter. I settled out this case, I've seen this happen in medical malpractice. The party who settled out, the two parties go, why don't we hire that person as the mediator? Which can't be done with the client's consent, because you're getting involved. Or, hey, that person settled out, we have a new party that can represent them, they need the client's consent. You can get that consent. But for the most part, all you have to do for former clients is go through the analysis. Is this related? And do I have information of the prior client that may be used against that client? Most of the time, when you get past a certain threshold, it's pretty safe to say you should at least still go through the, on my conflict reports I write down, no, no, no. You should at least go through the analysis of, do I have information that will be used against them? It's pretty safe to say on a 20-year-old file from an attorney who's no longer with your office, where the file's been shredded already, that the answer is, we have no information. Having said that, in the last year in my own firm, I did actually come across a hit that was the exact same matter 20 years ago popping up. Luckily, that lawyer had left the firm and taken the file with them, and we had no one who knew it. But you should still at least look at the old matters. You can usually rather quickly handle them as long as they aren't the same matter. And the knowingly represent the same, materially adverse, but also the only time they need to give consent is if it's the same matter, you're adverse to them, or you're using information relating to the representation to their disadvantage. Other than that, you just have to go through the analysis on former clients. Does that answer your question? And when you're looking at 20 years, it's usually pretty easy. Unless, by the way, in reality, if I remember that person, okay, the dog shooting case I had in 1981, I remember that case. If someone were to sue the same person now and wanted me to be adverse and were somehow related, I still have too much information potentially. Yes?
Another thing you might make note of is I recently got a case where I was representing a husband whose wife had been opposing me in another case with a different name. And her name had changed. And she actually brought it up and said, you should know that my name was X 15 years ago. Is that going to be a problem?
I have a slide later on that addresses that issue and another one. And when we started giving these lectures 11 years ago, the thing that most often led to people leaving worried and running back to their desk was the issue that you can't just do conflicts at the beginning of the case and be done with it. It's that you have to update your conflicts when you become aware of new potential parties, adverse discovery that might be resisted, or a name that you didn't know about. You should not be held to a standard of perfection, but you are required to make reasonable inquiry. There's a later, jumping ahead to something I mentioned on a later slide, my current practice, which is not firm standard or standard around town, is in my initial engagement letter. I recite, client, you told me these are the parties. You told me these are all the people who are on conflicts on. If there's someone else, tell me now. I'm not doing that to exonerate myself. I'm doing that to document. You're the one, my source of information is you, client, and I'm asking you anyone else, any other names. So in this particular case, your client might have told you, oh, by the way, my wife, you should run this name also. You still have to run that conflict as soon as you become aware of that person, if it's a material information situation, if it falls into one of the conflict of things, 1.7 or 1.9. But before you know about it, it might still conflict you off, but it would be a substantially good defense to the disgorgement risk that I told you about. There's only one disgorgement case, an outlier, that doesn't come about to you shouldn't have taken the case based upon the information you know at the time. All the others basically are you shouldn't have taken the case and you had enough information to know that. For the example you give, you didn't have the information to know that until later. While you might still be conflicted off, you would not face a more severe sanction at that point. If I don't know if the conflict would be a real conflict. Does that address the issue? Okay. This is the part I've already mentioned, using information to the disadvantage. In practice, the more time goes by, especially if you have a practice of shredding files, the easier it is to just say, we have no information. But in practice, if one of my, I unfortunately remember most of my clients, if one of my clients comes across my desk, I probably would have to do a more thorough analysis of whether I have this information. And when you have information, for example, if it turns out that you're now adverse to someone you represented for 20 years on other matters that you represented for 20 years, you probably would want to get a disclosure. One of the things I do at the very least is I make a disclosure that we've determined we have no information that's material. If you disagree, let us know. That's not asking for consent. It's saying we've done the analysis and we don't have it, but if you disagree, object now. I do that because there is now in Washington a case, and there wasn't for years, but there are federal cases, that basically starts a clock ticking. You can't sit on the conflict and object 2 years later. There isn't a definitive black line, line as to when it is, but you want to start the clock ticking. You don't want them to come up a year and a half later and go, hey, wait a minute, you had a conflict, you should never have been on this case. And so if you have any concern about whether you have information, whether they might object, the former client might object, my advice, this isn't standard of care and this isn't required, is to raise the issue now and say, if you disagree, say so. Yeah. And I haven't had that blow up in my face yet. I've had one person disagree and then we got a consent. But so you raise it early, and like in Med Mal, it's almost like a dance shuffling who represents whom frequently. So if you're now adverse to a doctor you once represented, for example, I would raise it and get it taken care of. Even if you believe there is no conflict, I would say so, but I would raise the issue. I also tell my client first the strategy in case my client disagrees, because the client might say, hey, you don't have to do that, I don't want you to do that because it will cost me my attorney. But then I want the client to know you run the risk they'll raise the issue later on. So the client probably can't veto me if I really think there's a conflict, but if I don't think there's a conflict, I want them in on the discussion.
Chris, I have a referral question. Does the Bar Association have a recommendation as to length of time for file retention?
I believe they used to, and I suspect they still do.
Okay.
But I cannot answer that question off the top of my head. We are 10 years.
10 years?
And we are, I would say, 10 years at a minimum. I once did a seminar on this subject for healthcare and found that different types of records, some of them go 50 years. I mean, if there's lead involved in your case, you may actually have a statute in Washington that says the file must be kept for 50 years. So there are a lot of specific little rules, but as a general rule, I believe always at least the statute of limitations. I believe 7 years is common. Obviously if there's a minor or an incompetent person, it might go on almost forever. But the bar number that I recall vaguely, I think, was 7 years as a recommendation, but it wasn't a hard and fast rule, and I haven't checked it recently.
Thank you.
But they can all be kept electronically now.
Yeah.
Query if you want to. I mean, yes, this isn't like when Vogel and Gates stopped existing and there were two large warehouses down in Soto full of records going back to 1880 in hard copy that they didn't know what to do with. It could be a fairly small database. But I just wrote 2 file closure letters today pointing out in there that, tell me now what you want, and in 10 years this file will be destroyed. That's in our engagement letter, that's in our closure letter. And I keep a few things after that, like proof of the engagement, proof of the resolution, so there's like 2 documents. And other than that, do you really want the file after 10 years?
I don't want them. I don't want them after 1 year. I want them out.
And I'll give you another reason why I like not having
for storage anymore.
I'm at a firm now that goes back many, many years, and we have decades and decades of data in our conflict report. At the point where I'm confident files have been destroyed, which is really closer to 20 years, I pay much less attention in terms of whether or not we would likely have information related to the representation, because I am more confident the file has been destroyed. That allows me to take the position at 1.9 that we cannot have information to the detriment of the client. So that is the process we've been discussing here. And it's not simply answered by whether the matter is an open or closed status file. That may answer whether it's a 1.7 conflict, but it doesn't answer the 1.9 conflict. Multiple clients in the same matter. I've hinted at this already. It can be done. There is such a thing as aligned interests. It's important to clearly document your scope, and it's important to clearly engage the clients in the discussion and make sure they agree. One thing about aligned interests, we can't negotiate the terms of their alignment. In other words, I can't say, hey, if you agree to this and you agree to this, I can represent you both. Effectively, you two have to agree to it, because I can't represent either of you against each other or between each other. So there still must be two more things in this, one of which is you must say, hey guys, it might go south in the future. We're even putting this now in a lot of our husband and wife relationship, because we are in more than one state which have community property and not community property. We're now generally using joint representation definitions and agreements for husband and wives. And at some point they might divorce, they might have adverse interests, and even when they're not divorced, if there's significant separate property, we almost always have a joint representation agreement. And they must know that if it turns adverse, one of the potential risks of representing both of you is we may be conflicted off of both. Tell them that up front, so they don't at that point refuse to pay you. Because if you didn't tell them up front, they're going to say, well then we don't want to pay you for the bill that's already passed. That's a traditional problem. You should be covering issues of loyalty. The confidentiality and privilege issues relate to, if I represent both of you, our discussions are still confidential and privileged as to everyone else, but not as to between the two of you. So if you two are in a fight, there's no privilege between the two of you. And if one of you comes to me and says, don't tell me this. That's what John Strait, giving a lecture once called, pick your plaintiff. Because at that point, all I can say is, you can't do that and either have to terminate the relationship now or one of you is going to sue me. Because you cannot meet that obligation in a joint representation situation. And there's always an advantage, it's always cheaper, but there's always risks, and these should be documented. And as I said, we're even doing this in a lot of the marital community situations now, which I think historically we didn't do as much. It's requested frequently in employer-employee, marital communities, multiple defendants in commercial claims, and in multiple plaintiffs against a common defendant, even though there are even touchier situations that are about settlements. Colin and I have done an entire presentation on multiple claimant, 1 hour on it. We're not going to do an hour on it today. Anyone here represent plaintiffs? Okay. Well, you represent the state in subrogation matters. And this is the point, the downside risk. If they get a divorce, or if the one with separate property realizes, hey, my separate property is at risk, I have separate interests, you may be kicked off representing both of them. Remember, privilege does not attach between both of them. I would say 20 years ago, I wrote some agreements contrary to this comment under the old rules for joint representation that were not so equal. Haven't done that since the new rules came out. A business with a client. Practically speaking, the worst problem I always have to face when counseling lawyers on this is that it's usually the client's idea. That is to say, why won't you invest in my business? Don't you believe in me? And the client does not want to go spend money on another lawyer to get the consent for you to do this business. Now, during economic hot times, it's often the lawyer's idea, I'll work for stock. I happen to know that a lot of the I will work for stock agreements did not have full RPC 1.8 agreements with them, and they still got honored, but that's still doing business with the client. What is not doing business with a client? Your initial negotiation of fees. There's an exception in the comments that says that is not doing business with the client. And as we've covered, accepting compensation from one other than the client. Obviously, insurance companies, I have had serious historical issues addressing this with other family members and tenders of defense, as you heard me mention earlier. The reason for that is, insurance companies, it's fairly straightforward. It's a fairly regular thing, and I have yet to meet an insured who doesn't go, yeah, I want them to pay for it. So, I mean, that's a really simple situation. And in most cases, it's easy to explain contractually. You probably have to share the confidential information. And there is a case, a reported case out there where the court actually said, okay, you should have told the insured that they didn't have to follow the insurance company's advice when they wanted to settle it if you didn't want to settle, but that they would probably be forfeiting their coverage if they didn't do it. So there's stretches of where you might want to go, but the real more serious issues, and I know you raised hands before, tendering of defense. Who's your client? Okay, your client has tendered to you a tender defense and your client accepts it. Both clients are still in the case. Who's your client? By the way, your clients continue to do business and you'll continue to have your client hiring you. Are those two clients adverse?
You talk too fast.
Okay. The answer to that question is the clients were adverse until the tender was accepted. So there's a bunch of documentation you can do on behalf of your client before the tender is accepted. And I'm careful, I do all that stuff before the tender is accepted. But once that's the case and you've gotten this joint engagement written up, now both those clients are your client. What happens the next time that both these clients are sued? You have conflict. So this is the one place where your tender acceptance agreement as well as your joint representation should contemplate a foreseeable advance waiver discussion. Bearing in mind that advance waiver discussions can always be, permissions can always be revoked. But tender acceptance is something we all do all the time. At least I have. And I've started writing sometimes 3 separate documents, including, by the way, this is not standard of care, this is not normal, but if I really, my client, Gene's client, really wants to be able to hire Gene again, we cannot enforce the agreement, the prospective waiver agreement. But Gene's client can enter into a contract with your client saying, you've agreed contractually with me that you will not object to my use of this client or this lawyer in the future. I can still draft that agreement before before the tender is accepted. I can't draft that agreement once the tender is accepted because I'm now representing both clients. So this is, I think, a thornier issue than we've been giving thought to in terms of tender acceptance. And I think that's where the 1.8F has to be covered, along with all the joint representation issues, along with future conflict waiver issues.
Is that comments on that?
Sorry, what?
Are there any comments in the RPCs on that?
No, not really on tender acceptance. There are comments with respect to joint representation. I think that the common practice of tender acceptance has been de facto, Gene still has one client. And your client going, we're taken care of now, we don't have to worry about it anymore. In reality, your client's still in the case. And annoyed that Gene is contacting them to get discovery responses. And so the clients tend to play into the fact that we aren't putting too much attention on this because, hey, our tender's been accepted. But if you actually analyze it, you've got a joint representation and you've got a 1.8F scenario, and Gene has to be prepared to say under 1.8F, I will still assiduously, a word that's no longer in the rule, represent your client as well as his client. And they're jointly represented. But there is no comment that comes out and says, here's how you handle a tender.
Well, and it's not uncommon in that situation for if there's an insurer involved, for them to hire separate counsel when they accept the tender.
I found that comparatively rare, except
hiring separate counsel?
Because usually they're trying to save money and hire one counsel. But I have had at least one scenario where my client accepted a tender, proposed to the tenderee that we use one attorney, me, and the person who tendered said, no, we want our own counsel. And indeed, we referred them to someone with whom I could work, who actually is in this room. But we referred it out, and we both worked on the case, and I took the lead. I mean, I took the lead in the case. But that's the other thing about the tenderer. You don't have to say yes to the joint representation. How many of you have had instances where the tenderer didn't say yes? I've had one.
I've had.
Okay, you've had some. But at that point, then, the carrier or the self-insured or the person accepting the tender should be hiring separate counsel.
Well, and it depends on if there's a reservation of rights, too, right?
Actually, no.
Okay.
From the point of view of, you're talking about the insurance company's duty. I'm not.
Right.
I'm talking about the lawyer's duty. And there are a number of occasions in each of our practices, probably, but I know in mine, where an insurance company has come to me and said, you can represent both of these, can't you? And I've occasionally had to say, no, I can't. You know, this employer-employee situation where our defense is to point the finger at the employee who is acting outside the scope of an employee. You really can't represent both all the time. I'm talking about the lawyer's duties.
Right.
And there will be times when the lawyer has to say, if they don't consent to joint representation, I can't do it. And that does happen. It's comparatively rare. It's dangerous to assume consent. This does not require documentation, but please do. It's easy. And as I said, for insurance companies in particular, and even for tender acceptances in most cases, at the outset, they're saving money. They're happy. They're happy to say, yes, I agree. And now, with the broader concept of confidentiality, and now that we're acknowledging the insurance company isn't the client, it is well to cover with the insured, if you can keep their attention long enough, you know, confidentiality issues, and that you will or won't be sharing. I have found this to be a biggest problem, actually, when a parent is paying for, say, the criminal defense of the child, which I've had to help set up several times. When a family member is paying for representation for another family member, you have better be clear up front, oh, by the way, I don't report to you. You're just paying. Because that's not their expectation. And without the consent of the actual client, you're not going to be reporting to them. You're just going to be sending them a bill. And your bill better not have too much confidential information in it under those circumstances. And I find this, it's most problematic in a family setting. Just to understand how far this goes, you have to not only get the informed consent, doesn't have to be documented in writing, no interference with your independence of professional judgment, and it's still confidential. I put the Bullivant case up there, which covers a number of other issues, but there's one really important thing about the Bullivant case that actually does make our lives easier. If you don't know about this case, it's the case where Brad Maxa adopted the judgment call rule, which is a great jury instruction you can have defending lawyers. But unfortunately, under the language of the case, he also made it virtually always a question of fact and probably not a summary judgment matter. However, at the end he goes on, you know, the insurance company tried to sue the law firm in this case. The insurance company, in addition to Clark County Fire District. And they said, the insurance company isn't the client. They don't get to sue the insurance defense firm. So that is a fairly important, nice thing for the insurance defense counsel in the case. Things about the process. You know, I've been a litigation defense counsel most of my career. And you'd be amazed how many times, not only do we not necessarily initially know who the client is, but the person calling me with a case doesn't know who the client is. And I can't really do a conflict check if I don't know who the correct corporate entity is, I don't know who the client is, and I am often surprised that the person calling me, and even in a self-insured company, I say, well, who is the entity here? Who's the real client? Long pause. You need to get the correct client, the correct spelling, and every potentially adverse, potentially interested party right up front and run the conflict. And as I said before, I like to document that. I also like to document whom I'm reporting to if it's a constituent. And if there's going to be a joint representation, we generally try to make sure that the joint representation for the company and the constituent is not signed by the same person. Under certain parts of the notes, that's required, but as a general rule, Mr. CEO, Mr. Company, we're representing both of you. Here's a joint representation letter. I don't want you signing for the company after you. I want you to find someone else to sign for the company, or else it might be challenged later on and get us in trouble. Document what you're told. You know, take copious notes during intake. Intake is when lots of mistakes are made, including, by the way, it's not in the chart, one of the biggest mistakes people can make during intake that I've had to defend large corporations over, large law firms over, is the use of the word you. I am pleased to represent you. Who do I represent? If it's an entity, always define the entity. I've had a CEO try to conflict a very large law firm off a case saying, I thought you represented me, even though the client was pretty clearly the company, but the letter said you. So try not to say, we are pleased to represent you, unless it's a single individual. And document the scope. You know, we didn't always used to do that in the old days, but in terms of defending law firms, a well-documented scope of representation can actually lead to a summary judgment victory in many cases, because it may be something where you've had scope creep or gotten off the mainstream where there's something that's done wrong, and if you document your scope clearly and stick to it, it's an easier case to defend. Okay, insurance company hires you to defend the insured. Who are the clients? Does it matter where it is? Yeah, in Oregon, it may be both. I've actually had a long debate today. If it has to be both, and no, it doesn't have to be both, but it's so blurry, you should assume it's both. If you're doing work in both states, that can really complicate conflict clearance. Trust me, that's what I spent most of my day doing. Do conflict issues still arise between insurance companies and insureds, even if your client is clearly insured?
Absolutely.
Okay. Two cases really cover this. Tank versus State Farm, which I think is pretty clear, and Arden versus Forsberg, which was at Court of Appeals last year and the Supreme Court on late September this year. This is one that Mark referenced. I have some slides at the end if we get that. I won't quite get that far, but when you access the materials, there are slides on it. You'll want to read Arden. Arden really does suggest we have a lot more disclosure obligations about potential conflicts. Although Arden basically upheld the dismissal of the case on sort of a no harm, no foul analysis, it did basically say, you know, they should have said that we've represented the insurance company, or that we have this ongoing close relationship with the insurance company. They should have made that disclosure. So if you read the Arden case now, there's a good argument that we might have to be making some more disclosures to our clients, the insureds, if it's coming from a regular source and we work with a lot, because it might materially limit us. Not because we have a real conflict, but because, dear client, you might be concerned that because I get 200 cases a year, you know, from client Gene, that maybe I'm going to favor client Gene if they're over your interests. Even though in this case, they were quite clear, there was no evidence that Forsberg did not favor Hartford, or that they did favor. No evidence they did, yes.
Do you think that Arden stands for the proposition that a firm cannot do coverage work and litigation in the same insurance company, or that if they do, they should disclose that? Yeah.
I stated publicly when Brad Max's opinion came out at the Court of Appeals level that I thought it was wrong, because he basically said there's no conflict here even if they do coverage work at the same time. I think coverage work makes the carrier a first-party client, and that there is at least a material limitation conflict possible, so it should be disclosed and potentially waived if it's being done at the same time. If it's former coverage work, then you're probably talking about an RPC 1.9 issue, which may not require a full conflict analysis, but probably still is wise to disclose. I don't think Arden is clear on that. I think what Arden basically says is, we think the insured would want to know that you have this close and cozy relationship within that case, Hartford, where you get something like 100 cases a year.
Well, I know in practice, some carriers won't use the same firm.
Right. And I actually think it's cautious to not do so.
But then we all know firms that do both.
There are firms that do both. And I think that if the carrier is a first party, this is not standard of care statement, but anyone who would come to me for advice, and this is, you guys are not clients of mine right now, but the general cautious approach would be, if you're doing first party coverage work, you at least disclose and seek consent. And generally, if it's considered a conflict, you need consent from both sides. In RPC 1.9, you might not. Concurrent first-party work for a carrier puts you at risk of at least material limitation, if not concurrent conflict.
Particularly under Tank, if there's a reservation of rights letter in there anywhere, which there often are.
Under Tank, if there were a reservation of rights, I would like to think that the carrier wouldn't do it to you.
Well, I think it's a potential conflict just to have an insurer frequently sends you defense work, because the implication there is that in order to keep the business coming from that insurer.
Arden supports that.
And well, I lost an insurer client because I pushed through the settlement that the insured wanted.
Well, and that was your obligation.
Yeah, right, and the insurer didn't like it, and I said, well, I don't care. I'm sorry, not in those words. I don't care if you don't like it. This is what the insured wants.
Arden supports it, even though it said there's no evidence in this case that Forsberg did anything to favor Hartford. Yeah. But the fact that they have a long and, we'll just say, cozy relationship should be of interest to the client, because it might. So I think that's consistent with it. Is it required? Colin and I are debating whether or not we're going to tell people it's required. You can certainly read it as saying the prudent thing to do now is disclose the nature of the relationship with the insured.
Yeah.
I just don't think disclose or to not be involved is, you know, if your firm does both.
Well, there's two. I'm going a step past the coverage. I think if you do coverage, you should be clearing it as a conflict. Brad Maxa disagrees with me, and he's a judge in the Court of Appeals. But I think if you do coverage, you clear it as a as a conflict. This goes a step farther. Arden says if you get a lot of work from them, you should be disclosing it and potentially clearing it as a conflict because of material limitation. So it's not even a question of doing the first-party coverage work. It's just your sheer volume of work from one source may limit or bias your freedom to act independently on behalf of the client. And I think that you can read Arden as saying that you now have to disclose the nature of your relationship with the carrier.
And you definitely think it's a waivable conflict.
Yes. Almost everything's a waivable conflict except giving coverage, you know, doing both sides of one thing. One of those stories about being on the RPC committee 30 whatever years ago is what is a waivable or unwaivable conflict almost consistently split the room down the middle with law professors on both sides. So what is a waivable conflict is a very blurry line, except when you are on opposite sides of the same matter. That's not blurry. So you don't give coverage advice to the client, you know, in this situation. You make clear that sure that's clear in your initial scope letter. We're not going to be giving you coverage advice. We will not get involved in a dispute between you and the insurance carrier. But that doesn't prevent you from telling the client when they need to go get coverage advice, which I think you're obligated to do. But I think the question you're asking is it waivable to have 100 cases a year from an insurance carrier and to still take each case? And I think the answer has to be yes. Unless the client has the chance to say, I don't feel comfortable here. Now your insurance carrier isn't going to be happy when they have to go find some other counsel because you told them that. But I think that it's arguably what we should be doing now. I'm saying arguably because I don't think they come right out and say you must do this. Yes?
Chris, are you saying that if a firm does coverage work for a company and then the company assigns a third-party case to them, let's just make it really stark. It's a different form. They've never done any coverage work. They've never done any coverage analysis under the particular coverage that's applicable to the third party, and there's no reservation of rights. I mean, it is what it is.
That makes it.
You're saying you need consent there, or you just need to disclose?
Okay, in the absence of a reservation of rights, I would seek consent, probably saying what we have here is a potential conflict that there is no conflict now, but there's a potential conflict, so I want to clear it in advance.
Okay, well, how would I describe that conflict?
We actually use the word potential conflict because if there becomes a dispute, such as if there are reservation of rights issues, then under Tank, you know, there is an actual conflict between the interests of one client, the one for whom we do coverage work, and another client whom we're defending in this case. And it's unrelated coverage work, but that is the definition of a concurrent conflict.
But my hypothetical was no ROR.
Right. Once you don't have the ROR, it's not an active conflict at that point, but you certainly have the potential for one. So I would disclose that there's something here rather than having it come up later, usually. Do you have to at that point without an ROR?
So
Probably not.
Another fact, which is pretty common, is that the third-party coverage says the company has the right to assign counsel.
Yep.
And there's no conflict.
But once again, remember the coverage issues with respect to what obligates the company are different from what you have to do. That's we've answered that more than once. Is that a time limit I'm getting from Maggie?
No.
Oh, okay. I do think, I'm giving, you got the site here for Arden. You should probably read Arden and consider reading the Court of Appeals level too, because they're slightly different facts mentioned. The Court of Appeals, which basically let Forsberg off completely saying, hey, there's no problem doing both at once, I think was a little bit too simplistic. Meanwhile, the Supreme Court is a little bit frightening in terms of, it lets them off, but it says, but this, but this, but this. And so the dicta in the process could give all of us a much heavier burden. This is, yes?
If you're not doing any coverage work for the carrier,
yep.
Are they a client subject to 1.7?
No.
So it's not it's not a waive. You talked about waiving the conflict. That's between clients, right?
Not only.
Not a client. How does it even come on?
What words did I highlight in the slide about conflicts 1.7? Material limitation. And when you read the Arden material limitation,
right.
When you read the Arden case, I would interpret that dicta as saying, getting 100 cases a year might materially limit you because your bread is being buttered by the carrier, and maybe your client should know that. And you've read Arden. I think it says that.
Yeah. But then do you have to get the conflict in the litigation sense and the coverage sense? So you're defending insureds in litigation, you get a conflict waiver there, and then you get a conflict waiver for the
No, I'd make one conflict waiver, but anytime you get a conflict waiver, you do it for both sides. Except the material limitation issue, arguably the insurance company might not see it. But I think you're real. Do you remember what I said during Mark's presentation? The growth area is material limitation. And this is one of those examples where in the last 2 months, material limitation has taken a quantum leap up in terms of our consciousness.
So Chris, let's try this again. So John and I, our firms have very similar business profiles, and so,
I know your firms.
Hundreds of cases a year from physicians insurance. And
which is physician owned too, so their physician should know that.
It is very, very rare to see an ROI. In a blue moon. And so I'm trying to think what I would disclose, right? I could disclose that, hey, we do a lot of work for PI, right? Okay. So the other next phase would be, you have no ROR, you got $1 million limits, which is typical, and you may want to settle the case, and you think if I detect that PI really doesn't want to settle it, I'm gonna evaluate the case as not being worth limits. Well, that's simply solved because if the client wants to get out of it, you're going to send them to another lawyer to write a hammer letter.
Right.
So I'm like.
I think your firm has sent those to me before, actually.
Yeah, well, sure. But so what am I asking the client to consent to?
At this point, we're calling it, with no ROR, we'll call it a disclosure.
Yeah.
Because what you're disclosing is, we don't think there's a conflict.
This is hearsay. Well, it's hearsay to you, not to me.
Be careful, this is being recorded.
Yeah.
But do you remember?
Who was the expert in art, right, for the defense for Forsberg?
Yeah.
And he said it's not required, not standard of care.
And then Gould said it was. I think it was Gould was the other expert.
Yeah, no, Straight was.
Gould was in the Bullivan case. Sorry. Yeah.
Disclose, but in no ROR, don't need consent.
Remember what I said about the 1.9 in terms of when I counsel someone, which was you're disclosing to find out if they object. So if you disclose and they say, hey, wait a minute, I have a problem with that, then you go through the consent process. But I think when you read Arden, what it's basically saying is, this is a potential material limitation. It sort of needs to be at least disclosed, if not consented. Do they give a clear, bright line? I don't think so. But if you read it it's frightening enough that you should at least be disclosing it. Meanwhile, your physician clients are probably delighted that you do 100 cases a year from this. And a comment I will make, internally I make this comment. Conflict checks, conflict communications are actually good marketing and client touch opportunities when handled in a positive fashion. So, there's a total positive spin on this. Hey client, we're really good at this. Physician Insurance hires us 100 times every year. Now, you are still a client, but you should be aware, we do a lot of work with Physicians Insurance, and so we're very familiar with this stuff. You can only spin it so much before a court might look at it as you're really hiding what you're disclosing. But it doesn't have to be you should be afraid of the fact that we do 100 cases a year for Physicians Insurance, or however many you do. You see what I'm saying? And I actually tell people, you should never be afraid to make a client conflict communication. It shows clients early on you care about them enough to bring it to their attention to resolve it, even when there's some doubt. And it almost never blows up in your face at the beginning of the case to go, hey, I don't think I have a conflict, but I want to run it by you. Does that answer?
Yeah, I mean, what threw me is it suggested that getting an advanced waiver in a situation where I don't know that there's a conflict and I can't even describe what it might be.
Well, the conflict is kind of like what I had with my insurer. They didn't like Washington law. They didn't like Tank. They didn't like they thought they were the client. They didn't like the fact that I, quote unquote, pushed the settlement the client wanted onto their policy that they had to pay. And if I want to keep that company's business, well, I want to cater to them, and if I'm catering to them when it comes to the settlement, I'm not adequately defending my client, the insured. So that's where the
and that's what the court's talking. The Supreme Court is concerned about that in argument.
That's where it's coming from. Right. And I did my job for the insured, and I lost the business.
The business, sure. And I think many of us over the years have experienced that. That's why I tried to phrase this. I just want to understand the phrase in terms of no ROR, no coverage work. I get a lot of work from this company.
We do. We disclose that.
But I'm going to say,
in the absence of an ROR,
Chris made it sound like what you're saying is you need consent, advanced consent.
Yeah.
You need at least disclosure. If you have an ROR or if you have active coverage work, I think you do.
Okay. Yeah.
If you have an ROR, I think it's an ROR in the absence of coverage work. I have very little insurance work now, so if I have an ROR case, it's probably a one-off case that's been sent to me as a conflict by someone. I don't think I actually have to disclose very much. Yeah, I'm being paid by the insurance company. This is the only case I have with the insurance company. Oh, I have 100 cases with the insurance company and there's a reservation of rights out there. I think I'd go into more detail. Because Arden, the Supreme Court, is concerned about whether or not you are protecting the client's interest in the flaky facts of that case, which, as Mark pointed out, it started with someone shooting his neighbor's dog. And the bad faith was it didn't get settled before the criminal charges were brought. And they settled the bad faith case and then continued on after settling the bad faith case and sued the law firm after they settled the bad faith case. Those are sort of a summary of the facts of Arden. Okay, I'm out of time. I want to cover just like two things. The one thing that people forget about in confidentiality is it's actually a two-step process. The rule actually says, first you get consent to share the information. Remember, getting consent under 1.6 does not have to be confirmed in writing, but we try to incorporate this in our consent letter that first we got that consent. Only after you get that consent from each can you go about getting the conflict waiver. I've had a few conflict waivers stop when a client said, no, I don't give you permission to share information. It stopped the process and the waiver did not happen.
Can the two clients agree that, can they agree that there's certain information that they will not authorize you to share with the other?
Yes, but if that leaves you unable to share the necessary information to get an informed consent, it will stop the process. You need to be able to get materially important information to get what's required for the consent. I wanted to point that out because I think people frequently forget that first you must have permission to share information, and it's actually spoken of as a two-step process. Other thing I'd like to cover, I'm aware that in some insurance defense firms, I'm sure no one here, the consent process may well be delegated either to someone at the insurance company, oh, you guys talked about this when you sent me the case, or to a paralegal or someone like that. It isn't that you cannot do that. It's just you assume the risk if you do it. That is to say, you could theoretically have your secretary doing all the informed consents, and you'd be in some vulnerable position if you were doing that. If the person said, I didn't get any information, I just signed the letter, that isn't a valid informed consent. And I have a couple of slides. All these slides will be accessible, right, Maggie? Yes. So I'm really proud of these, but I haven't updated this in terms of what has to be in writing, what has to be in advance, what doesn't have to be in writing. It's totally inconsistent. And what is writing is actually a remarkably broad number of things, including a voicemail. I've run out of time. Thank you for all the questions, which is why we ran out of time before covering this. I want you to know that at the end of this is two of the cases we were supposed to discuss. There's several slides on Arden versus Forsberg that gives you a bunch more of the facts. And the other case that's summarized here is Scheibel versus Iman, which is important because it has to do with the withdrawal process and the fact that at least in this case, where they were being sued for withdrawing, when the court approved the withdrawal, it said you can still sue them for other things, but they're exonerated for the withdrawal. So the court approval process actually got the firm off the hook for that one claim. With that, thank you very much.